The reality is that what has been happening is that the ability of this House, the individuals who sit on these green benches, have simply had their ability to make the laws that they are entitled to make on behalf of the people who vote for them being reduced to rubble. That is what has been happening, and in return we've been faced with an increasingly dysfunctional European Union that did not work in the interests of the British people, and that is why we got the result in the referendum. It was the people who voted, and interestingly, if I may make another point on this, when that decision was taken to hold the referendum, it was decided by 6-1 in this House of Commons. We voluntarily agreed that we would abdicate our right as members of Parliament to let the people of this country make that decision on their behalf. So that all the resistance we've seen over the last 3 years from the opposition benches and from a number of our recalcitrant colleagues, many of whom are no longer in the House, was based on a complete failure to understand that the decisions that were taken in that referendum were authorised by Parliament and indeed by themselves. Furthermore, when it came to the Withdrawal Act in 2008, and I did the first draft of that bill, which was accepted by the government, what it said in Section 1 was that the European Community Act 1972 will be repealed on exit day. That is now, in fact, the implementation period day, but for practical purposes it comes to the same thing. What I'm saying is this: the opposition, religiously or irreligiously, depending on how you care to put it, decided that they would oppose that bill in principle, which they did on second reading and third reading. Every single Conservative, even my recalcitrant colleagues, even Kenneth Clarke, voted for the Withdrawal Act in third reading. But what the opposition did was to deny not only the sovereignty that was being restored by the repeal of the 72 Act, but also the democracy which went with it. That is a fundamental issue. And what they did was to destroy their credibility with the British people. And I believe that the ordinary man in the street, the people who voted in the last general election, understood this. I've already made the point about the fact that the European laws are made behind closed doors by majority votes. Nobody can say that decisions that are taken, which we had to accept because we had no alternative, were laws made by our elected representatives. I have never heard such trash coming from a front bench as the suggestion that the fact that these people happen to be elected members of Parliament in the Council of Ministers conferred upon them some form of democratic right to decide. I'll certainly give way.
I'm grateful to my honourable friend. He's making absolutely the right case about sovereignty. Also, an extension of this, I mentioned Van Gendenloos and Costa versus Ennals. And the point about those two is they were judicial statements. One was direct effect, and the other one was, of course, the whole idea that European law had supremacy. Now, they were never voted on in this House. No. Nobody agreed to that. Nobody said this is what we wanted. And that led to something which is quite interesting. All of the imposition of the extension of welfare payments to EU migrants who came here was a judicial review of something which we had never voted for. It was never voted for, and it cost us a lot of money.
A very good point, and I'll just add to that this, that those cases were, in fact, before we came into the European Union, and they actually invade the very concept of the constitutionality of this country and of other countries too. Because what it does is, those cases say, is that we are obliged to obey not any law, not all laws, but even constitutional laws. Exactly. That is the point. It's an utter invasion. This is a complete and total destruction of the decision of people in the ballot box in general elections. That is what the problem is, and sovereignty and democracy are intertwined at the heart of our constitutional system. Those are the points I want to make, and I honestly say to the Honourable Lady, she really ought to reflect on the rather absurd propositions that she put forward in her speech. She cannot prove a single point of the kind that she's just mentioned. One last point.
Most grateful, I'm trying to give away. The key function of members sent here, the earlier parliaments were in Shropshire, of course, it's a regrettable tendency we've had to have them in Westminster the last few hundred years, is that we pass supply, we vote funds, and we are responsible for monies raised from our constituents. And no taxation with a representative is fundamental. The current rules are in complete breach of that. It's worth reading a national NAO report that between 2005 and 2015, the EU demanded £642 million back because of the unsatisfactory manner in which the last Labour government introduced CAP reform. There was absolutely nothing a single member of Parliament could vote here or do to stop that money being demanded from the UK government.
In conclusion, if I may, Mr. Deputy Speaker, simply say I entirely endorse what my right honourable friend has said, as indeed I endorse what my other right honourable friend has said. The bottom line is that what happened when we passed the Withdrawal Act in conjunction with the general election which we have just won gives us back the opportunity to be able to make laws on behalf of the people of this country in a democratic constitutional arrangement of such importance that I believe that this will go down as a historic moment when this bill goes through on third reading tomorrow.
Thank you very much. I'm rising to primarily address amendment number 35 in my name and its intersection with clause 38. But I can say to the Minister I don't intend to push this to a division, but I do want to highlight some of the issues that are arising from it. More generally, just on the point around parliamentary sovereignty, I want to make a couple of comments, indeed around the irony, as other members have done, with respect to the level of delegated powers that are about to be created in terms of this bill, and also the lack of scrutiny around the future relationship, which is of particular importance to us in Northern Ireland, but of course for all colleagues right across the United Kingdom as well. And indeed, we've had the situation today where the Northern Ireland Protocol, which is of such importance to us in Northern Ireland, and indeed has almost bedevilled the process around Brexit for many years, was only programmed for, in effect, 2 hours today, and a lot of the Northern Ireland voices weren't properly articulated on that particular point. The concern of my amendment is really around the rights protections under the Good Friday Agreement. The Good Friday Agreement is, of course, an international agreement, but implementation in domestic law does fall to the UK Government to ensure that things are entirely in order in that regard. And the agreement does set out a comprehensive set of rights, including issues such as the political participation of women, the right to freely choose one's residence, freedom from sectarian harassment, a statutory equality duty, and perhaps most significantly the requirement for the incorporation of the European Convention on Human Rights into UK domestic law. Now, most of the debate in Northern Ireland and beyond around Brexit as it pertains to our situation has largely focused on issues around borders, the business community, the economy, trade, and what the future holds in that regard. But the rights issues as well are something that people are deeply concerned about for a whole range of reasons. Article 2, Section 1 of the Protocol on Northern Ireland and Ireland does provide a commitment that there will be no diminution of rights, safeguards and equality of opportunity, and of course that is very much welcome. But we have seen a gradual weakening of the level of commitment to rights protections if you go back to the original draft of the joint report in December of 2017. And the European Union has been very clear that it does fall to the United Kingdom government to ensure that the rights under the Good Friday Agreement are protected going forward as part of the future relationship and other factors as well. The very specific concern I was trying to raise with the amendment is that there does seem to be an inconsistency between Clause 7A and Clause 38, which is a particular focus of this section of the debate. Clause 38, of course, stresses parliamentary sovereignty, notwithstanding 7A, which is used to give some degree of reassurance that there won't be any threat in terms of rights. So there is that potential that 7A could be overridden in some shape or form. And the reasons why we have some concern in this respect are several. First of all, not all Good Friday Agreement rights relate to the European Convention itself. Some are broader than what the Convention contains. Also, some of the proposed legislative commitments only apply to Northern Ireland's departments and public bodies, and they don't extend as far as the UK Government itself. And in there may well be some potential danger. And there's also concerns as to how the UK Government has, to date, fully respected some of the rights under the Good Friday Agreement. As members will appreciate, identity is a very complex issue across these islands. But it has been managed to date through a number of different forms, through, for example, the Common Travel Area, more recently then the Good Friday Agreement, and of course, hitherto the joint membership of the European Union by the United Kingdom and the Republic of Ireland. And up until now, both of those jurisdictions have moved in tandem as regards issues around the European Union, including, for example, around matters such as the Schengen Agreement, which the Republic of Ireland have also opted out from. So we're now faced with the first time ever that we're going to see the UK and Ireland move in a different direction in terms of the European Union, and that may well throw up a whole range of issues and challenges and anomalies that will need to be managed successfully. So Brexit strips a lot of those protections away and perhaps does create a certain degree of risk. And if I could maybe just make one particular example in that regard, members may well be aware of the Emma de Souza case regarding the issue in terms of an immigration case. And what that is pointing to is the absence of the UK Government having reflected in UK domestic law, particularly in terms of revision to the 1981 Nationality Act, the ability of someone who is born and resident in Northern Ireland to fully have the right to identify solely as Irish and to have Irish citizenship. What the law is currently saying is that anyone born in Northern Ireland is by birth automatically British, and to many that goes against both the letter and the spirit of the Good Friday Agreement. As long as that case, and indeed other situations, go unresolved, there is this latent fear of these anomalies persisting and indeed potentially growing, particularly if there is greater divergence between the UK and the rest of the European Union, including in particular the Republic of Ireland, and the implications for what is a very complex situation that has been managed in particular by the Good Friday Agreement on a faltering basis over the past 20 years, but nonetheless managed, and we may well be into very difficult and rocky territory. So I think it's important that the Government does reflect in terms of some of the fears that are being expressed in Northern Ireland. And while I'm not going to push the amendment today, it's important that the Government reflects on that, and I certainly give way to.
The member must, of course, reflect that the fact of the matter is that the Republic of Ireland is an independent country in its own right, and by being independent, it is entitled to go its own way. And if it wants to go a different way with Europe, it's entitled to do that. We wouldn't want to restrict it and say it has to come with Britain. I'd be delighted if after the European, whenever we leave the EU, that and Europe will increase its bill of membership to the Republic of Ireland. Whenever they see how costly it is to be part of that membership, maybe they will then have a national conversation about their role as Irish citizens in the EU. But ultimately, that is a choice which the Republic of Ireland has made, that it wishes to stay within the EU, and we shouldn't try to be restricting their hands either.
Well, I'm always grateful to hear comments from my counterpart in Northern Ireland, but I think it's worth stressing for the record that there is no significant movement, debate whatsoever in the Republic of Ireland around any form of our exit, as perhaps it could be framed. There is deep commitment to membership of the European Union in the south of Ireland, as indeed there is on a majority basis in Northern Ireland, as well as is the case in Scotland and other parts of the UK as well. While, of course, Ireland will make its decision to remain as part of the European Union, it is, of course, the UK that is diverging, and that's a debate that has been had, and I recognise the outcome in that respect. But nonetheless, it is important to recognise that Northern Ireland is a complex society. It only works based upon sharing and interdependence, and a very careful set of balanced relationships have been built up over the past number of years, with support of both front benches in this House over that period. And Brexit does potentially strip away some of that sticky plaster over perhaps some of the cracks, and we don't exactly know how things are going to work out. So it is important that the government does pay regard and is sensitive to the very particular implications in rights terms for Northern Ireland as the Brexit process unfolds. Thank you.
I welcome Clause 38 to stand part of the bill, and I pay tribute to my honourable friend from Stone for being one of the co-authors of that excellent piece of government-proposed legislation, and I also support the Minister in opposing various new clauses and amendments before us. And it seems to come down to this question of what is sovereignty. And I think the public understand it so much better than many of the opposition MPs seem to do. The public fully understand that our constitution should be based on this proposition that the public decide who should represent them in the House of Commons, and then the House of Commons decides what laws are appropriate, what taxes to raise, how to spend that money, and at the end of 4 or 5 years, or shorter time period sometimes, the public then get to judge whether we collectively made a good job of it or not, or whether there is some new configuration of members of Parliament that can make it better. So the public are ultimately sovereign, but they trust us, their elected members, with their sovereignty for a period of up to 5 years to exercise the powers of government. When we first joined the European Economic Community, the country was assured that that sovereignty, that set of powers, would not be damaged in any way. And to underwrite that promise, the government said, correctly then, that there would be no matter decided in the European Economic Community that could be forced on the United Kingdom against its will. We always had a veto, so that if they proposed a law or a charge or a tax which we didn't like, we could use the veto. And over our years of membership, we have seen those vetoes gradually reduced, those powers taken away, so that in more and more areas today, while still a full member of what is now the European Union, there are huge swathes of policy areas where we are not free to legislate where we wish, or in some cases not free to legislate at all, because it is entirely occupied territory under the community acquis. And the ultimate sovereign power in the United Kingdom today is the European Court of Justice. That is the ultimate appeal of any legal issue, and they can overrule what the two houses of Parliament decide, they can overrule a statute, they can strike down a law passed in this place. And it is that which a majority of the British people decided they thought was unsatisfactory. When they had voted many years ago to support our continued membership of the European Economic Community, it was called a common market and misrepresented as a free trade area, which of course is rather different from a customs union with complex rules. And they were given that assurance that their parliament would still be able to choose their taxes, spend their money, and pass their laws in the traditional way, and that turned out not to be true. And the loss of those freedoms was progressive under the Single European Act, under the Maastricht Treaty, under the Amsterdam Treaty, the Nice Treaty, and above all the Lisbon Treaty, the final culmination of that journey towards a very strong European government, which was superior to the United Kingdom government, and the implied substantial strengthening of the wide-ranging powers of the European Court of Justice, because every directive and every regulation that was passed, and there were thousands of them, not only produced more directly acting legal power over our country that we could not modify or change, but it also gave so much more extensive powers to the European Court of Justice, because they are the ultimate arbitrators of that body of law. And it is that body of law which this legislation today is seeking to put under United Kingdom control. And we've been arguing over this for 3.5 years now. The public thought it was a very simple matter and told us to get on with it. We had a fractious and unhelpful Parliament until recently, which did all in its power to thwart the wishes of the United Kingdom electors being put through. And I would hope today, after a second general election, and after a referendum where the British people have made clear that they wish their sovereignty to rest again with them and delegated to their parliament, that the opposition might have understood that and might have understood that currently, contrary to what we've been told by the Labour front bench, there are a very large number of areas where we cannot do as we please. Let's start with the money. Yes, we wish to take back control of the money. This Parliament cannot decide to reduce the amount of money it pays to the European Union. They decide that. They determine the bill and they enforce the bill. And I hope that ministers can reassure me that after December, at the end of the implementation period, that will cease. And we will only pay when there is an agreement that we accept between us and the European Union for services or joint policies which we wish to undertake as a sovereign nation. We cannot go on accepting their hand in our pocket and taking our money under their legal powers. And I personally think it's a great pity that we've had such delay in exit, because I resent the £1 billion or more net a month we are paying in, which will continue, I'm afraid, throughout this year, when I would like that money for priorities in Wokingham and in the constituencies of other colleagues here in this House of Commons. And I find it very odd that so many MPs are so dismissive of the significance of the money, given the quite important role it seemed to play in the referendum campaign itself, and given how colleagues are normally very keen to see increases in expenditure on public services in our country, and yet they don't make the connection that if we carry on paying those very large sums to the European Union, it limits our scope to make those increases which they would like. It also means we don't control our own taxes, and so our country cannot choose how to tax any of our sales. That is determined for us. It has to be the VAT tax system. We had to introduce that when we joined the European Union. There are arguments for continuing some kind of VAT system, but surely we want to decide what rates it's levied at, and we want to decide what items it is levied on, because there are quite a number of items which I think it should not be levied on, where I think I would find agreement across the chamber. But we are not allowed today to remove that from green products, for example, because that is against European Union rules. So I look forward to our opportunity to shape our own taxation system as soon as we are properly out. There is then the issue of when do we actually have control over our law. And what I hope that Clause 38 will achieve is, if the European Union decides during the implementation period to pass laws which are particularly penal on the United Kingdom or are damaging to our commercial and economic interests, that we can use that reassertion of parliamentary sovereignty before the expiry of the implementation period to make sure that particular law does not apply to the United Kingdom. Because there is otherwise an invitation to anyone of bad will in the European Union to think of schemes which would be disadvantageous to the United Kingdom during this implementation period. There's then the issue of borders, where again the Labour front bench seems surprisingly dismissive of a very important question which has been in our debate through the referendum and subsequent general elections. And I think there is a general view in the country that goes well beyond Conservative voters, that there should be a fair system of entry as between EU and non-EU people, whereas at the moment EU gets preference. And I think a lot of people feel there should be some overall limitation on the numbers of people coming in seeking low-paid work or speculatively seeking work, and that they favour some kind of a work permit system, which is quite common in many other advanced civilised countries. Because we wish people who join us to be welcomed, because we want them to live to a decent standard, because we accept a commitment to pay them benefits and find them subsidised housing if that is their requirement, surely it should be in our power to decide how many people we welcome in this way, and that should be related to our capacity to offer them something worthwhile and in relation to our economic needs. I give way to my right honourable friend who's done so much on this area.
Yeah, can I just take him up on one particular point? He said, should we wish to give them benefits? The reality is right now, for the British government, they have to pay benefits even to families working over here who the families are not with them. And this is roundly disliked across Europe, but they all accept there's nothing they can do about it. because it was the Court of Justice that imposed this as part of freedom of movement. It was never debated as part of freedom of movement, and it was never supposed it would happen. That is an end to sovereignty when you no longer can change something and make that decision.
So, my right honourable friend has put it brilliantly. That is exactly the kind of limitation of our sovereign power and our freedom to make decisions that please our electors that I've been talking about. And it's quite an important one, given the history of this debate. I then turn to the Scottish Nationalists. And I agree with something which the Scottish Nationalist spokeswoman said, and that is that we only want volunteers in our union. We are Democrats. We believe that the union works, but that if a significant portion of the union develops a feeling that it's not working for them, that is something that we need to test. And so I was a very strong supporter of accepting the SNP idea just a few years ago that there should be a referendum, and that referendum had the full support of the United Kingdom Parliament, which is of course the sovereign authority for these purposes on union matters. And I also fully agreed with the then SNP leadership when I talked to them about it, and I think had formal exchanges recorded in Hansard, where they said that they agreed with me that whichever side lost should accept the result of the referendum. And they also agreed with me that this would be a one-in-a-generation event, not a regular every 5 years event until once I got the answer it liked. And I do hope the SNP will reflect on that, because yes, we are Democrats. We want volunteers in our union. But you cannot pull it up and examine it every 2 or 3 years with a referendum, which is very divisive and very expensive and damaging to confidence in economic progress. You should live with the result.
I thank the honourable member for giving way, but does he accept that we did respect it? We've been here for 4.5 years. We wouldn't have been here if we didn't respect it. We'd have been independent, and we wouldn't be being dragged over the EU cliff at the end of this month. Yes. But he should accept the claim of right that Scotland's had for 331 years didn't disappear in 2014, and it's his party that have changed the entire fabric of the United Kingdom and cannot continue to treat Scotland with disrespect as to their views going forward.
Just before the Honourable Gentleman continues, we don't want to be dragged down a debate about Scottish independence on Clause 38. I appreciate it was in response to what he said. So let's continue to debate these amendments and this Clause 38. John Redwood.
Good advice, but I'm trying to address the SNP point related to their proposals over how we treat devolved government fairly and whether we are listening properly to Scotland. And I think, yes, we are very much listening to Scotland, but we do have to understand that the matter of the Union is a responsibility of the Union Parliament, and the matter of our membership of the European Union is also a responsibility of the European Parliament. And it's the Honourable Lady's misfortune to have been on the wrong sides in 2 referendums, but it has been a deeply democratic process in both cases as to whether Scotland stays in the Union or whether we stay in the European Union. But I do wish to urge my right honourable and honourable friends on the front bench to remember that there is a 4th country in our union, and that is the country of England. And we are very reasonable people, and we don't go on and on about English issues. But I do think when we get to this debate today over how the different parts of the United Kingdom are consulted and respond to the issue of how we leave the European Union, England too needs to have a voice within the government and needs to be seen to be an important part of the process. Because the overwhelming vote for Brexit was an English vote, because England is a very large part of the Union in terms of numbers. And that is important, just as the Scottish and the Northern Irish view is also important. So I do hope the government will look at this machinery of government issue and make sure there is within government a clear and definitive English voice. And in due course, I think we need to discuss whether this Parliament should not only have an English Grand Committee that can veto proposals that England doesn't like, but also an English Grand Committee that can make proposals that England wants, because that would do something to correct the obvious imbalances which make this a particularly difficult matter to settle when the largest part of the Union, with the overwhelming Brexit vote, is not formally represented in the discussions.
Thank you.
Thank you very much indeed. It's a pleasure, thoughts, to follow the member for Wokingham and the member for Stone. I think on the issue which we're talking about is sovereignty and democracy, it is worth just remembering that obviously the original referendum in 2016 was one person, one vote on one issue. And there was a clear majority at that point to leave. And sometime later, namely 2019, we had another vote. Obviously, we had a general election. And if that was counted on the same basis, one person, one vote, we had 14.5 million people voting for the sort of oven-ready Brexit that was on offer, and 16.5 million for a people's vote or remain. Obviously, that vote was done on a different basis. It was done on a constituency representation basis on a number of issues. And it's clear that what was decided was that we would have a Conservative government with an 18 majority. That's clearly understood. But to try and actually conflate those two issues, I think is wrong. And I will take the intervention just in one moment, let me finish my sentence. And therefore, I think there still is a compelling case that the oven-ready Brexit that's being sort of railroaded through, that in my view will be a reckless Brexit, will undermine the sovereignty and power and financial credibility and trading credibility of Britain, should go back to the public for a final vote. I'll give way to the honourable member that during the election I remember senior Labour people arguing very passionately that it was fine for a Leave voter to vote Labour, and they weren't all in favour of what the honourable gentleman just said. So I don't think you can say the Labour vote was definitely a Remain or a second referendum vote in all cases.
I think you'll find it was the proposition, and so we're clear on this. I said Remain or public vote on the deal. And the Labour Party position was essentially that the oven-ready Brexit would be bad for Britain in terms of making us more divided, weaker, poorer, more isolated, etc. And that we could put together a better Brexit that protected our jobs through trading alignment, our environment, and our workers' rights through a dynamic alignment of those conditions. It kept us closer, and that would be better.
But just ask the honourable gentleman to resume his seat. It's very interesting, but he's not really speaking to the amendments or to this particular clause. It's more a third reading speech. There'll be a long opportunity tomorrow. If he has a speech to make in relation to these amendments, then we look forward to hearing it. Geraint Davis.
I do apologise for responding to the speech that's made on the subject I was touching upon by the member for Wokingham, and I won't go on about that anymore. And coming back to the focus, which is the two bits I'm going to talk about, was obviously the clause on sovereignty 38, and indeed number 28, which I was mentioning then, which is about whether we should have a confirmatory referendum. And I was just making the argument, if I may, Mr. Chair, which I'll stop making, that in support of that particular proposal, 28, that there is a legitimate case for a confirmatory referendum on the grounds that most people voted for either Remain or a referendum. And of course, the position of the Labour Party was to have a referendum. But going back to the sovereignty issue, the member for Stone and others have made the point that what they defined as sovereignty was the idea, and I accept this is an idea in the minds of many voters, that if we've got sovereignty, we can have all our decisions made here, and we'll make them and decide everything, and everything will be all right. Now, intuitively, that sounds very sensible, but in practice, is that really going to be what's going to happen? I would contend that this Brexit will reduce sovereignty, and therefore this clause, 38 is misleading. In particular, at the moment we have pooled sovereignty in the EU, where we have, we are one of 28 countries, but we have a proportional vote to our population. And what that means in majority voting, where the honourable member was suggesting if things are rammed through and we have got no consultation, they just happen to us. We've got a veto opportunity, even on a majority vote, together with Germany, for example, which is obviously the biggest player, and therefore they're very worried that we're leaving, that they won't be able to exercise, in accordance with us, certain restraints or constraints on the EU. And ultimately what will happen is if we do have a close trading relationship with the EU,
EU. And after all, 44% of our trade goes to the EU. From a Welsh point of view, it's more like 60%. And we will have to have some level of equivalence, which will mean we'll have to be in accordance with the standards that are decided in a closed room, without us in that closed room. So surely that isn't more sovereignty, it's less sovereignty. We'll have to make the decision, do we agree with something that's been decided without us, as opposed to where we could argue and block it with Germany and others?
Well,
or I will in a second. Or do we want to be out of the room and deciding whether we accept the rules that are coming over, and if we don't accept them, it might hinder our trade. And that doesn't sound like sovereignty improvement to me. I will give way.
Phil, I'd just be pleased if my honourable friend could tell me what definition of sovereignty he's using, because it's completely confusing me. I've just checked, and it's normally, the normal definition is the authority of a state to govern itself. But he's talking about majority voting when we might be in a minority. What is his definition of sovereignty?
Yeah, what we're talking about in terms of sovereignty is the freedom of this Parliament to influence the outcomes for our electorate. And what I'm saying, as he chunters in his seat, is that we will be in a situation where we would move from a situation where we can influence rules that will be applied in Britain to one where we cannot influence those rules and they'll still be applied. We're not suddenly leaving and going to the moon. I know there is a move on the other side that we should be semi-detached or worse from the EU and sort of thrust ourselves into the fond arms of the WTO. But what I was saying earlier to the Minister, going back to that point, and I have had some experience of this as being a trade rapporteur on behalf of the Council for Europe at the WTO, is that we end up in a situation where we're negotiating with 164 countries with one vote, not proportionate to our population. Some of these are dictatorships and all the rest of it, as opposed to being in a club of 28 mature economies with a very strong bargaining position within the WTO. The WTO, of course, as I mentioned earlier, is being undermined by the US, who just wants their own massive power to decide everything rather than rules. And also the WTO has got existing rules that are contrary to what we're allowed to do within the EU. So going back to the point about sovereignty, we'll be in a situation where, and I appreciate the Minister may not want to do this, but if the government of Britain at some point in the future wanted to bring things back into public ownership of the railways or whatever, then the WTO would be able to stop us. The WTO also has rules about patents, which will increase the price of drugs. Now, I don't think this is something that people in the street, as it were, inverted commas, voted for. And then the other thing is, of course, they will impose, as will trading relationships, bilateral trading relationships with the United States. We will have new systems of courts, arbitration courts and panels with independent judges that aren't democratically elected in the way the European Court of Justice is, who will make decisions as to whether big companies can either sue us or threaten to sue us for not pursuing various activity, or they can block our legislation. And what I'm specifically talking about, just by way of example, in case there's any ambiguity here. So if you take the case of Lone Pine, it's a big fracking company, they sued the Canadian government because Quebec had a moratorium on fracking. And they said it wasn't in the interest of the climate change, the environment, or whatever they said, whatever it was. And so we might have a situation, for example, where we start some fracking here, which we have, then the Welsh government says we don't have fracking there, and we have a investor-state dispute settlement tribunal, and the frackers come along and say, well, okay, we can't have this, we're fracking, and they sue the British government. And so is that sovereignty and control in a normal, and of course, just one moment, in any normal situation, no, of course it isn't. So in other words, there will be courts available which will fine or threaten to fine the British government for passing legislation to protect the environment and the public health of our citizens, and it will intimidate future governments from doing that. And so if we wanted, by way of example, to introduce a sugar tax, and of course we have, when that happened in Mexico, there was a investor-state dispute settlement, attack on that. And so there's anything we do, what about a plastics tax? We want to do that, then we'll be attacked for that. This isn't sovereignty, this is madness and self-harm, at which point I will will allow the member on that point.
I really do not understand what his front bench and he are up to here. It is as though they are trying to rewrite the whole concept of what the world order in trade is about. The EU has to abide by WTO rules just like we will when we leave, and we already do. There is no issue here that is going to change. WTO rules apply to the EU as stringently as they apply to us, and when we leave and become a voting member, they will still apply to us. The difference is, if there becomes a debate for change, we have a vote in that, which we do not now because we subsidiate. We have that underneath the EU. So his argument is specious and total nonsense.
Well, that was very helpful. What the honourable members fails to understand is that clearly when there was the big debate over TTIP, for example, well, these ISDS clauses are used all the time by the Americans on fracking and other issues. Once we are in a situation where instead of being in the powerful trading bloc of the EU negotiating head-to-head with China or with the United States from a position of strength to sustain our environmental, our workers' rights, our standards, then we will suddenly instead be broken free, semi-detached, turn our back on our biggest local market, as him chuntering, and then what will happen is this is what will happen, and it's already been discussed in the trading arrangements with the United States. The United States will say, right, you're on your own now, and we're going to have this relationship, and we'll enforce it through this international tribunal, and that is what is going to happen. And so what will literally happen, just one moment, and what will literally happen is if you just take a simple protection, REACH, whereby in Europe, if the honourable member was making chemicals, you'd have to prove they were safe before marketing them. In the United States, he would just be able to market those, and the Environmental Protection Organisation, they would have to prove they're harmful, and that's why they sell asbestos in America, and that's why there'd be pressure for us to have asbestos in our brake pads here. That's why there'll be pressure for have hormone-impregnated meat from America imposed on our growing children who will have premature, pubescence and all the rest of it. And I know they think that's sovereignty, but I don't. Yes, I will give away.
I thank the honourable member for giving way. Is he aware that a threat to the sugar tax is already within the trade papers which came out, registering the discussions that have already been happening with the US, and the sheer threat of a government, whether a devolved government or here, being dragged through an investor-state dispute settlement can create a fear of public health measures, such as we have in Scotland, minimum unit pricing on alcohol, which this Parliament has not got round to, and might find that they struggle to get round to because they would be challenged, and therefore that threatens the public health of everyone in the United Kingdom.
Hear, hear. I mean, I think that is a very important and excellent point, that it is the chilling factor of the threat overhanging. And on the specifics, let's be clear, and lots of people talk about the health service here and the impact of this on our health, and the Americans arriving and taking our data and all the rest of it, privatising the health service. But apart from that, let's think, as is being thought of, the public health impact of these sort of changes on sugar, because we spend £12 billion a year in the NHS on diabetes.
To intervene again, and I understand the point. He's trying to link this to the overall concept of sovereignty, but we are now talking about future trade deals rather than the bill, clause 38, and sovereignty. I would just encourage him to come back to the clause if he would. Thank you.
I'm very grateful for your guidance. I guess the point on track about this is that if sovereignty is about our ability here to make laws without intimidation, without interference. That's what sovereignty is. If we find ourselves outside the EU and we can no longer put forward, for example, a tax on sugar that would reduce our cost of obesity in the NHS, and so we've got a situation where 6 teaspoonfuls of sugar in a yoghurt light or whatever it is, a Muller yoghurt, or a 9 in a Coca-Cola, and we want to let people know that and drive down sugar content and drive down diabetes and drive down health costs. If we're instead fined because the projection of a manufacturer of a sugar-impregnated product isn't then less, then we won't be able to do it. So that isn't sovereignty. If we can't protect our, well, my point is, if we can't protect our environment, our public health, our trade, and we'll be under the cosh of these companies suing us in these arbitration panels, that isn't sovereignty. And therefore, this clause should be struck out because it's completely misleading. I will give way.
Thank you. Look, there's an awful lot of what the honourable gentleman has said in terms of constructing his argument, which I actually agree with a great deal of what is said. But his conclusions are sort of hypothesised on a trade deal which have yet to be done. The important point about all of this is it's our sovereignty to decide what goes into the trade deal. And if we don't want to put stuff into a trade deal, it doesn't matter what the investor courts say. They can only adjudicate on that which is in a trade deal, and that what goes into a trade deal is decided by this sovereign parliament. And that's where his conclusion is completely wrong. To actually what was quite a strong argument that he was putting forward to start off with, I do agree with it. But the conclusions are completely wrong, given the sovereignty of this parliament.
I'm very, very grateful for that. For that intervention if there's any lack of clarity, because what I'm saying here is that the moment we are in the EU, and obviously we do lots of trade with the EU, 44%, etc., and we do quite a lot of trade out, through the EU and directly with America and elsewhere, so we're in a reasonable position in my view. If we come out of the EU and we suddenly find we need to make up for lost trade, we'll be under a lot of pressure to do a deal very quickly with the US. Secondly, we'll be in a much weaker position because we'll be standing alone in a weak position. They're a big player and they know it. And therefore, they will try and get what they want. And as has been pointed out on the sugar example and there's fracking examples and other examples, they will do this. And what's more, they have got these powers, ISDS, that's the State Dispute Settlement, that's part of their normal bilateral trading agreements, and that is already recorded in the trading relations. And the idea, his idea, which I respect, that we could in theory say, no, we don't want this, we won't go ahead with that, and we could decide that there. Yes, we could decide that there, but it would be a huge economic cost, and there'd be enormous pressure to, and we've got to get all these other trade deals done as well, to agree. And in terms of the assumption that's been made that we can just carry on as before with all the other bilateral trading agreements with small countries, say Chile, I'm doing this arbitrarily. If you were Chile, Mr. Chair, then you would sort of think, hold on, I'm negotiating now, instead of with a big EU, with a relatively smaller UK, and so I want a better deal. So therefore our sovereignty in terms of our power to deliver what our electorate wants is reduced. And therefore, intrinsically, I feel our sovereignty is being intrinsically undermined rather than enhanced, contrary to what's been spun out here. Yes, I will.
The member speaks of trade as all one way. Of course, one of Germany's biggest trading partner is the United Kingdom. Do you think that they want to go down the road that the member's saying? Germans will want to make sure that they continue to have good trade relationships with the United Kingdom, no matter where Britain is when it comes to its position within or outside of the EU.
Yeah, no, that's very, very helpful. And that is a key point that's being made. And let's get that one clear, because something like 44% of our trade goes to the EU. So it's enormously important to us, our trade. But in terms of the EU overall, about less than 5% of their trade comes to the UK. So in terms of the balance of power, and within that, it is the case that two of the countries, Netherlands and Germany, have got a significant trade surplus with the UK, and the others don't. So and what the EU wants to do quite reasonably as a bloc is to protect its standards, its environment, its workers' rights, and not be undercut. And already we've seen in terms of, we will have to, on the environment, in terms of sovereignty, we want a better environment. But the government's already deciding to we'll be withdrawing from the carbon trading situation. We'll have our own carbon tax. But in fact, my understanding now is that the proposals for the government is that in terms of the carbon emissions tax, we'll be charging me £16, and the EU emissions tax is £25 a tonne. In other words, we're already becoming the sort of pollution dumping ground. And the more we diverge negatively away from the EU, the less we'll be able to trade, and the more we'll be in the hands of whether it's the US or the Chinese or whatever. And that isn't sovereignty, that's just being in the hands of others. So on your guidance, Mr. Chair, I think I've made my point that in terms of in terms of we will be poorer and weaker and more divided. This isn't about sovereignty. This is about the abdication of sovereignty, and I deeply regret it.
Right. Robert Courts.
Thank you very much, Mr. Speaker. It's an honour to take part in this debate. I would like to make just very brief comments, and I would like them to be directly on the subject of Clause 38. I'd like to say a word or two about parliamentary sovereignty and the need for the clause as I see it. The phrase parliamentary sovereignty or sovereignty we've heard a lot of recently. It's a much used phrase, it's a much misused phrase. And whilst it's certainly something that is subject for debate, what it essentially can be understood to mean is that this place is the supreme law-making body in the country. It is one that makes the law, and it is one that cannot bind its successors, so the law can be changed. The law is made after an election, at which you stand on the basis of a set of promises, you enact those promises, and at the following election, the electorate judge how well you have performed and how well you have kept up with those promises, and then they make a judgment at the ballot box accordingly. That principle has been affected by European Union membership in significant ways. For these purposes, I'll just address the effect of the ECJ. The first of those comes from the effect of the facts attainment case in 1989, which meant that for the first time, an Act of Parliament could be disapplied, the Merchant Shipping Act in that case, if it was incompatible with European Union law. The second major case is Van Genderloos, which established the effect of direct effect, not direct applicability, but direct effect of rights enshrined in European Union treaties enforced by European Union citizens without recourse to Parliament. That has a serious effect on sovereignty because it means that rules are being made out with the procedure of this House. The Labour front bench are academically correct when they say that parliamentary sovereignty already existed from 1974 onwards, because it was always possible that this House could repeal the European Communities Act, which we have now decided to do. In essence, what Parliament decided to do was to hand over wholesale spheres of competence, as the European Union calls, in certain areas, meaning that they would make the rules in those areas, and Parliament would simply rubber stamp through the means of direct effect and regulations. So when an individual rule was made that we didn't like, there was very little members of this House could do about it on those specific issues. They could, of course, revoke their consent for the entire scheme and repeal the European Communities Act, which is what we have now done, but they couldn't on an individual basis. So that consent came from this House. The reason why this is such an important clause is that there is a different period about to commence. Since 1974 all the way up to 2019, Parliament has consented to the rule-making powers and machinery of the European Union through the European Communities Act. Once 72, I beg your pardon, I'm very grateful for the correction. The 1972 European Communities Act. Once we are out of the implementation period, then all of the rules that affect the people who we govern will be made in this House. We will make promises when we stand for election, we will implement them to the best of our abilities, we will then stand on that record. And every point is subsidiary to this. So all of the points that we've been hearing about future trade deals, for example, all are follow on the principle of sovereignty and direct democratic accountability that happens in this House when we stand for election, when we speak, and when we return for election. But that will not be the case during the implementation period. Yeah.
Just imagine a scenario where the United Kingdom might have a trade deal with America, and this Parliament decides it's going to say no to genetically modified or hormone beef or whatever. How free and how sovereign does he think this Parliament will be in a scenario where they've got a trade deal with America? There won't be.
I'm grateful for the intervention because it illustrates precisely the point that I'm trying to make, which is the nature of what sovereignty is. Sovereignty is held in this place, and this place makes the law, and it is the superior governing body. If there is a trade deal with the United States, then the electorate will have their chance to have their say on whether they agree with it at the next election. And if his party, or any other party wishes to change it, then they stand on that manifesto basis, and then they stand for election accordingly. And if elected, then they enter into negotiations to change it. I'll take one more.
I'm very grateful, and the gentleman's been very generous. When you have a trade agreement, of course, you'll have to have some dispute resolution mechanism. Currently, we've got the European Court of Justice to do that. When there's a trade deal, if there's a trade deal with America, there will be a dispute resolution mechanism which is giving away sovereignty. You're back to square one.
No, that's a misunderstanding of the nature of a trade dispute body. Every treaty has to have some sort of dispute resolution. The Honourable Gentleman is quite correct about that. And if there's a trade deal with the United States or any other body, yes, of course, there will be a trade dispute resolution. But it will be adjudicating on the terms of the agreement that have been agreed and approved in this House. The major difference with the ECJ is the one that I've already referred to, which is its judicial activism, which is the fact that it creates law that is over and above and has to be applied by this House, whereas when law is made by our domestic judges, this House is able to enact legislation which overrides it. I won't. That's okay. I just want to make my final point, and then I'll sit down. All right.
Grateful to the member for giving way, but does he recognise that the existing investor dispute settlement resolution systems that exist in all the treaties are very one-sided? They allow private business to sue government, but it does not allow government to sue business for the deaths of smoking or pollution or other damage they've done.
I don't agree. I'm very grateful for her point, and we're certainly getting into the technical detail now, which is perhaps exactly what we should be doing at this stage. But she ignores the independent element that takes place in any of these independent arbitration mechanisms in international trade organisations. I've taken a number of interventions and I've made the point I'd like to make. I would like to conclude simply by saying why I think that Article 38, Clause 38 is necessary, and why the Amendment 11 simply misses the point, which is that up until while we remain members of the European Union, Parliament had consented to the lawmaking facility, the lawmaking structures of the European Union. That consent has been withdrawn once the European Communities Act 1972 has been repealed, and we're in the implementation period. We do not want to be in a position whereby we are forced into dynamic alignment, whereby rules are passed that we do not have a say in. We need to make sure that it is clear that this Parliament maintains and retains the right to disagree and to diverge from those rules if they wish to do so. For those reasons, Clause 38 is entirely accurate, it is needed, and the amendment, the Amendment 11 from the opposition front bench simply misunderstands the point.
Thank you. Patrick Grady.
Thank you, Sir Gary. I've just enjoyed sitting here for the last couple of hours watching the Maastricht Rebels farewell reunion tour, although it does appear they're getting some young recruits. But fair play to them. They've been trying for 40 years, and they're finally going to achieve. They think they're going to achieve what they always wanted. And as I say, I feel slightly sorry for them because I don't know what they're going to do after the 31st of March, but 31st of January. But we had all the greatest hits. We had the supreme lawmaking body, we had Brussels bureaucrats, common market, no taxation without representation, and of course the platinum hit, parliamentary sovereignty, which is being enshrined in this bill for absolutely, as the member for Bristol West and the member for Central Ayrshire said, for absolutely no reason at all. Because as the member for Witney has just touched on, this Parliament, in as far as the UK Constitution stands, has always had and has always shared, and in fact will continue to share its sovereignty. Because if you look at the devolution settlement, that is effectively what it has done by recognising the desire of the people in Scotland, Wales, Northern Ireland, and indeed with the various other regional assemblies that have taken place. Power has been devolved from this place, and aren't we all very grateful for it? So the notion of restoring parliamentary sovereignty is just completely unnecessary, and it's a total showpiece in this bill. Power has always been shared across the European Union and across the United Kingdom, and indeed the Right Honourable Member for Wokingham appears to be a reborn federalist. Maybe this is his new solo career now that the band is coming to the end of its tour, and I will happily join him in the further devolution and assertion of federalism across the United Kingdom if that's what he wants to do. But he should be worried because, as we said, parliamentary sovereignty is not being restored by this clause or this bill as a whole. In fact, what it represents is a power grab. First of all, a power grab from the devolved assemblies by taking back the right to legislate without their consent. And of course, this bill itself is an example of that, because as we speak, the Scottish Parliament is withholding its consent from this bill, and it is going to be ridden roughshod over by this House tonight and tomorrow. But it's also a power grab by the executive because of the sweeping Henry VIII powers that are included in this legislation and the accompanying Brexit legislation that has already been put in place. So the Brussels bureaucrats, that favourite hit of theirs, is being replaced by the new one-hit wonder of the Whitehall Mandarins, except it's one hit and for the rest of time if this Parliament doesn't stand in the way of what they are trying to do. So in fact, we're not restoring anything great here. And the Minister, I would be interested for an answer at some point on whether or not the European Statutory Instruments Committee is going to be reconvened in this Parliament. It was one of the achievements of the previous Parliament and the previous bills to have that enshrined in statute for the lifetime of that Parliament. So let's see it back here if they're so, if scrutiny is so important to them and sovereignty is so important to them. So this place will be diminished in terms of its powers and its sovereignty, and in due course it will be reduced in terms of its numbers, because there are 59 Scottish MPs who won't be sitting here anymore, because Scotland's power and sovereignty will have been restored to its Parliament, which it will then be very happy to share with its continental neighbours across the European Union as a member.
We are on, the question is, as regards clause 11, is it the intention of the opposition front bench to press that?
As the Minister had cleverly spotted, this was a probing amendment, and we have explored the concept of sovereignty extensively, so I therefore withdraw the amendment.
In that case, is it your pleasure that the amendment be withdrawn? Aye. By amendment by leave, withdrawn. We now come to, with leave of the committee, I'll now put together a single question on all the clauses and schedules to be agreed at this time. So the question is, the clauses 38 to 40, Schedule 4, Clause 41, Schedule 5, Clause 42 stand part of the bill. Many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to new Clause 2, with which it will be convenient to consider new clauses and new schedules listed on the selection paper. To be moved by
Mr. Thomas Simmons, I think.
Thank you, Sir George, very much. As is my first appearance at the dispatch box this year, I'd like to thank my constituents for re-electing me and send all honourable and right honourable members my very best wishes for 2020. And I draw attention to my relevant entries in the register regarding my own support from trade unions. I stand to speak, Sir George, to new clauses 2 and 3 in my name and the names of my honourable and right honourable friends. And may I say, first of all, from the dispatch box, that we fully accept that following the general election, we'll be leaving the European Union on 31st of January. But winning a mandate for that exit, as the government has, does not give ministers a free pass to avoid any scrutiny. Government should be held to account between elections as well as at elections, and that is what we on these benches as the opposition propose to do. And we will continue to make the case in the post-Brexit United Kingdom for jobs and livelihoods, for environmental safeguards, for consumer protections and employment rights, as we have done over recent years. And it is, Sir George, to the issue of workers' rights to which I first turn, which is the subject of New Clause 2. New Clause 2 is about protecting vital workers' rights, and Part 1, subsection A, ensures that the government cannot introduce any measures which would in any way have the effect of reducing in any regard the protections provided on the day the transition period ends. And we believe too that this must go further. 1B confirms that the government, after our exit from the EU, will ensure that workers' rights in the United Kingdom will be, as a minimum, at the level they are in other EU member states. I'll finish this part and I will come back to it. We will insist too that the government is held to account in Parliament on these objectives. The government must never be allowed to sell out the workers of this country, and we will not let the government off the hook. We will stand with those to whom this government and the Prime Minister has made promises, and I give way to the honourable gentleman.
I'm very grateful to the honourable gentleman for giving way, and I welcome his tone and his acceptance of the result of the general election. But will he in turn accept that in fact workers' rights here are enhanced, are greater than those enjoyed within the European Union? We don't need to be members of the EU. Let me just give you the example of sick pay, of maternity leave, of the minimum wage. Does he accept that those rights are already enhanced, and it's this sovereign parliament that guards those rights, not the EU?
I'm absolutely delighted to see the honourable gentleman giving credit to past Labour governments and their achievements. He's absolutely right about the national minimum wage. We can go back even further, talk about the Health and Safety at Work Act back in the 1970s, another fine achievement by a UK Labour government. But it is also the case that there are rights that have had their genesis in European law. Talk, for example, to agency workers. Think about the Working Time Directive. These are things we should be praising and things that we on this side say not just should be preserved but enhanced in the years going forward. And that's what this clause is all about. And I do say to the honourable gentleman that the government's record on workers' rights is concerning, to say the least. And let's just take the previous incarnation of this bill, back in October 2019, because Schedule 4 of the bill at that time outlined that, firstly, a minister would have to consult with businesses and unions on the impact of workers' rights on any new proposed legislation, and then state formally how that would happen. Secondly, the government would have to regularly report on any new EU directives. Now, at the time, those proposals were described by the TUC's General Secretary as meaningless procedural tricks, and that's why we on these benches put down a similar amendment to the one that is before us today, so that stronger protections would be in place. Now, I think quite simply that the position of the government in October 2019 was weak on workers' rights, and now it is even weaker. And let's be fair, if the Prime Minister cared so much, he wouldn't have moved the provisions on this from the legally binding withdrawal agreement to the non-legally binding political declaration. Why bother to make that change if it isn't to prepare the ground to make those changes in the future? And it isn't a surprise either, Sir George, that the government started off this Parliament indicating that what they want to do is attack the right to strike in the transport sector. None of these are the actions of a government that wants to, as it claims, protect and enhance workers' rights as the UK leaves the EU. These are not the actions of a government that claims it wants to make Britain the best place in the world to work. The party opposite, let us not forget, are the party of employment tribunal fees that were a barrier to those whose rights at work had been infringed and were seeking justice, and now they seek to ask for trust on workers' rights. Their record on this bears no reasonable scrutiny. The Home Secretary in the EU referendum campaign talked of, and I quote, the burdens of the EU social and employment legislation. Another member of the government said, and I quote, the weight of employment regulation is now backbreaking. The Collective Redundancies Directive, the Atypical Workers Directive, the Working Time Directive, and 1,000 more. Who was that? The man who now claims to be the workers' friend, the Prime Minister himself. This government can't and won't be trusted on workers' rights, rights that have been hard-won over successive generations by the Labour movement. That's why this clause is needed in this bill, to safeguard millions of workers in this country who deserve that continuous protection of their rights, and that's why the opposition will be pressing that new clause when the time comes. If I can move now to new clause 3, which sets out details about our future relationship, putting the protection of jobs and livelihoods at the very top of our priorities as we depart the EU, and it sets out the arguments that have been made by the opposition for some years now about a UK-wide customs union with a say in external trade deals and for strong, high-quality single market access. To ensure rights and protections Workers' rights, of course, as I've already said, but in other areas too, never fall behind those across Europe. And I also think, Sir George, of our manufacturing sector, our exporters, currently benefiting from tariff-free access to the single market. In all our constituencies, whether through direct employment or the many supply chains that exist, workers and businesses will rightly look to this House to protect their interests going forward, and that is what we should do. In the course of this Parliament, we will hold the Government to account on its record on jobs and investment, the basis upon which it secures the new relationship with the EU will have consequences for now and for decades to come. Now, Parliament has lost its right to set a negotiating mandate, so that task now falls squarely on the task of the Government. They will be judged on what they do and the impact it has on employment prospects up and down the land. Now, Part 3, subsection D sets out about participation in EU agencies, many of which have been debated in the course of our deliberations on Brexit in recent years. But I do want to focus and make some remarks about the issue of security, because in a digital age when crime knows no borders, the task of keeping the public safe faces extraordinary new challenges. Now, nobody can doubt the value of working together and continuing to work together on security with the EU and indeed other international partners. But I do say to the Government that the Government hasn't produced as yet a credible plan on how the current advantages we have, the current set of tools, will continue in the post-Brexit age. Now, in the political declaration, I'll give way to my honourable friend.
I thank my honourable friend for giving way, and he's making a crucially important point, because whilst I agree with the other parts of this amendment on customs union and the single market, security is an aspect that was largely lost in many of the debates that we had in this House, and yet we heard regularly on the Home Affairs Committee evidence from experts, from law enforcement agencies, from the Metropolitan Police and others of the risks to our security of not getting that comprehensive security arrangement in place. So would he agree with me that we should be listening to those experts and the Government should be listening to them too?
My honourable friend is absolutely right, and I do want to develop that, because I think one of the issues we have is that in that non-binding political declaration we have that aim for a broad, comprehensive and balanced security partnership, but at the moment it's just words on a piece of paper. We urgently need a plan. Now, the former Prime Minister, when she spoke at the Munich Security Conference back in February 2018, spoke about a security treaty with the EU27, but we are still waiting for the planned architecture of that cooperation. And I want to give some specific examples here. Things like the European Arrest Warrant, Eurojust and Europol are all critical to the successful investigation and extradition of wanted suspects or criminals. And to show how important this is, the National Crime Agency statistics, if you look at the period from 2010 to 2016, the UK made 1,773 requests to member states for extradition under the European Arrest Warrant and received 48,776 requests from member states for extradition. Now, not only can the UK bring people to these shores to face justice, we can also send dangerous people to other countries to face legal proceedings there. The Government has accepted, it seems, the importance of this tool. And its white paper of July 2018 said more than 12,000 individuals, and for every person arrested on a European arrest warrant issued by the UK arrests 8 on European arrest warrants issued by other member states. But that white paper also showed the challenge the Government faces. It said existing extraditions between the EU and third countries do not provide the same level of capability as the European arrest warrant. We cannot allow our capability to be diminished. And I'll give way.
I thank the honourable gentleman for giving way, and he's making a very important point. And before the last election, I produced a report with the all-party parliamentary group on consular affairs and deaths abroad that I chair. He may be aware that there are already significant challenges when our citizens die abroad or get into trouble or are incarcerated. And all of the officers and the people I have spoken to have said that Brexit is only going to compound those issues and make it more difficult for our citizens to get proper representation and support from the Foreign Office after Brexit. Does he agree?
I think the Honourable Lady is absolutely right to highlight the challenges, and I think that's precisely what I want to come on to develop. And my concern, and I heard the Brexit Secretary's answer yesterday to an intervention from the Honourable Member for the Rhondda, and my fear is that the Government's thinking just hasn't moved as yet beyond the implementation period. And we know the implementation period ends at the end of 2020. And what happens after that is so important, because it will determine what our law enforcement agencies have in their armoury to deal with pan-European crime. It is an urgent task. The issue, Sir George, of data sharing and continued data sharing is also crucial. Were the UK ever to lose access to the EU security databases, information that today can be retrieved almost instantaneously could take days or weeks to access, which would create, to say the least, a significant hurdle to effective policing. On Europol, how does the government see the future? Does it envisage full participation? Does it envisage only observer status at board meetings? We just don't know. And whilst the situation is critical, and whilst the position is wholly unsatisfactory, I should say that's the fault of the government and not those who work in our security sector. Because after all, the UK makes a great contribution to European security. Through the Schengen Information System, through SIS2 as it's known, the UK is contributing to the sharing of real-time data on wanted criminals, missing persons and suspected terrorists. And that cooperation is beneficial to us all. The data shared in that database used millions of times each year by UK police, and that surely must illustrate to all honourable and right honourable members the profound risk there is of no long-term deal on security. And in conducting the negotiation, the government must emphasise the UK's contribution and the mutually beneficial nature of European cooperation in dealing with the most serious organised crime on our continent. I listened carefully to what the new European Commission President said today. She said the threat of terrorism is real and we have to share the necessary information to stop terrorists from crossing borders and attacking us. She's right. When we are fighting crime, we are better working to eradicate it collectively than working alone, and we need a formal legal basis to continue to do so. That's why those issues in New Clause 3 are so important, and I commend it in New Clause 2 to the House.
Joanna Cherry.
Thank you, Mr Chairman. I rise to give support, the support of the Scottish National Party, to the official opposition's New Clause 2, and to speak to the following amendments: New Clause 8 in the name of my right honourable friend, the member for Ross Skye and Lochaber, and New Clauses 50, 51 and New Schedule 1 in my name and those of some of my colleagues, and also New Clauses 45 and 46 in the name of the SDLP. I want to look first of all at the issue of workers' rights, because I think what is being done in this bill is very serious, and that's why my amendments, New Clause 50 and New Clause 51 and New Schedule 1, seek to reinstate the missing clause and schedule that were in the October version of this bill. The government suggested that the substance of the deleted clauses will be covered in a separate employment bill, but this bill is yet to be laid before Parliament, and so we are understandably suspicious given the history of these matters. Now, it's simply not true or not accurate to suggest that the United Kingdom has done a better job than the European Union in protecting workers' rights. There are some respects in which the United Kingdom has progressed matters, and it's true to say that those came under a Labour government, and I congratulate Labour for that. I'd just like to develop my point before I take any interventions from the honourable gentleman. But there are many other respects in which the European Union and our membership of the European Union has advanced the cause of workers' rights. And also, judgments of the European Court of Justice expanding the law in the way which some honourable members seem to find so objectionable have also led to greater protections for workers in the United Kingdom. And of course, as well as the disappearance of Clause 34 that was in the October bill, as I said earlier today, this bill also removes the provision that pre-Brexit judgments of the European Court of Justice will continue to be binding on UK courts until the UK Supreme Court departs for them. Instead, now it has provision for ministers of this government to make regulations under Clause 26. I see the Minister's frowning at me, but we spoke about this in some detail earlier today. Regulations to certain courts and tribunals to depart from the CJEU case law. And of course, I think that underlines the concern of many of the trade unions in relation to this matter. And certainly I've read very carefully what Unison have to say about this matter, what the TUC have to say it, what the Scottish TUC have to say about it, and also what Thomson Solicitors, a well-known legal firm which many of us have had dealings with in the past, who've worked hard in the area of protections of workers' rights, have to say about this. And the fear is this, Mr Chairman, that the combination of the missing clause and the power which the government are taking to themselves to interfere with the Supreme Court's ability to overrule previous European Court of Justice decisions is that what will happen in the United Kingdom is a chaotic free-for-all on workers' rights, where the courts potentially could weaken existing workers' rights and ignore past ECJ rulings which trade unionists and workers across the United Kingdom have benefited from. And if that doesn't happen in the courts, then it could well happen as a result of unilateral action of government ministers in delegated legislation. And it's important to remember that working people in the United Kingdom have benefited from a number of recent landmark judgments by the Court of Justice, including the requirement for employers to keep records of all hours worked to comply with the Working Time Directive, something that's very important to many of our constituents. The ruling that employers might not have to factor overtime into holiday pay calculations, again very important to many of our constituents, particularly those who aren't as well paid as members of this House, including those who don't have a second job. And so, you know, really, we hear often from the benches opposite about how much they care about the working man and woman. But if they really cared about the working man and woman, they would support these amendments that I've put forward and the Labour Party have put forward. And they would give us the guarantees we require that there won't be a regression from the rights which many of our constituents have enjoyed as a result of European Union law. I'll give way to my honourable friend.
I thank my honourable friend for giving way, but isn't there also the other suspicion is that those who advanced the leave cause during the referendum campaign, many of them now in the Treasury bench and occupy it, were saying that one of the reasons they wanted to leave the European Union was to do away with workers' rights and to do away with employment rights. And now that many of them on the Treasury bench, the suspicions that many of us have are only going to intensify.
I mean, many members opposite, not all, but many have spoken about just the sort of free-for-all on rights that we fear. And of course, this partly comes from the conceit that somehow the United Kingdom, by which they normally mean England, has a monopoly on rights which is not shared by other countries across the world, including the other countries in the European Union. Unfortunately, the lived experience of working men and women across the United Kingdom is not one of confidence in governments of the UK to protect them, particularly when the governments are of the Conservative and Unionist Party. And that's why they've been so reliant on the jurisprudence of the European Court of Justice and also on directives and regulations passed by European Union institutions, in which, of course, Britain has had very significant input over the years. So really, I guess what my amendments seek to achieve and what the Labour Party amendment seeks to achieve is some minimum guarantees in relation to the continued enjoyment of many of these rights which exist only because of the European Union. I give way to the honourable.
Would you agree with me that the European Court of Justice fundamentally underpins our fundamental values of democracy, human rights and the rule of law, including what she said? And outside it, all of those things, workers' rights, the judiciary itself, which is under attack, and the rule of law is under attack, and our civil service, our BBC, there are all these institutions, and now a free-for-all, and it's not just workers' rights, it's the judicial system itself.
Well, I mean, as I said earlier, it's clear from the Conservative manifesto that they intend a rebalancing of the balance of power between the Executive, Parliament and the judiciary. And I think this comes from a sense of hubris about the Prime Minister's defeat in the Supreme Court at the tail end of last year. But of course, it's important to remember that wasn't a political decision. It was a legal decision. And I'd like to quote what Lord Drummond-Young, the distinguished Scottish judge, said in the Scottish Supreme Court when he said, "It's not for the judiciary to scrutinise the government. That's the job of Parliament. But when the government prevents Parliament from doing its job, then it is the job of the judiciary to step in to make sure that Parliament can fulfil its function." Now, I see that that comment from a distinguished member of the Scottish bench is going down like a lead balloon on the other side of the House, but it simply mirrors what Lady Hale was careful to do in the Supreme Court, to underline that these were legal judgments and not political judgments. So I think, you know, our membership of international institutions like the European Union and the European Convention on Human Rights separately have given important guarantees that regardless of the complexion of government in the United Kingdom, there will be certain minimum standards. The withdrawal from the EU undermines that in a number of areas, particularly workers' rights, and that's why these amendments are so important. And that brings me to the second point I have to make, which is in relation to the Charter of Fundamental Rights, which was, of course, removed by the European Union Withdrawal Act and is not dealt with in this bill. However, there does remain widespread concern about the effect of the removal of the Charter, because, as we heard at length in the last Parliament, there are certain rights guaranteed by the Charter that are not guaranteed by the Convention on Human Rights and aren't guaranteed by the domestic legal systems of these islands. And so I and my SNP colleagues believe that this Parliament should ensure that this bill doesn't lead to the diminishing of the rights of UK citizens or EU citizens living in the UK. And one way of doing that would be for the government to commit to conducting and publishing an impact assessment on the effect of the removal of the EU Charter of Fundamental Rights later this year. And that's what my new Clause 50 seeks to achieve, and I would respectfully suggest it's in the interests of certainty that no reasonable parliamentarian in this House who cares about the rights of his or her constituents could oppose an inquiry into the impact of the withdrawal of the Charter on their constituents' rights. The next clause I want to address, which is in the name of my right honourable friend, the member for Ross-Skye and Lochaber, and a number of other of my colleagues, is new Clause 8, which sets out a requirement for the UK government to negotiate a deal keeping the UK close to the single market and the customs union. Now, I have no intention of moving this amendment. I know the ship has sailed on this, but the reason for this amendment is really just to remind the House and put in the record the position of the Scottish National Party and the Scottish Government in relation to membership of the single market and the customs union. Because earlier today, Mr Chairman, the Minister said that the UK Government have engaged with devolved administrations throughout the negotiations to leave the European Union. But I'm afraid to say that the evidence of the last 3 years shows that while engagement has taken place, it has been very much a superficial box-ticking exercise. And that's not just the view of the SNP. I see others who represent seats in other devolved administrations nodding their heads. Now, in December 2016, the Scottish Government published a document called Scotland's Place in Europe, which was the first comprehensive proposal from any government in these islands to address the outcome of the EU referendum. And it contained an evidence-based analysis showing that the least damaging option for leaving the European Union, the optimum case being to remain, was to continue membership of the single market and the customs union. And the document demonstrated how that could be done for the UK as a whole, which, failing other parts of the United Kingdom, such as Northern Ireland and Scotland. And these proposals represented what was a very considerable compromise by the Scottish Government. But despite cross-party support in the Scottish Parliament, they were almost instantly dismissed by the former Prime Minister. Indeed, Mr Chairman, they were read more carefully by Michel Barnier than by the British Government. So Scottish Government colleagues engaged fully in good faith thereafter with the processes set up by the UK Government to apparently, and I use the word apparently advisedly, involve and consult the devolved administrations in formulating the UK position for withdrawal. And indeed, if we look back to the terms of the Joint Ministerial Committee on European Negotiations, which was set up for this very purpose and agreed in October 2016, it said that through that Joint Ministerial Committee, the governments would work collaboratively to seek to agree a UK approach to and objectives for Article 50 negotiations, and to provide oversight of the negotiations with the EU to ensure, as far as possible, that outcomes agreed by all 4 governments are secured from these negotiations. Sadly, it was soon clear that the UK government had no intention of honouring these commitments. There's more to engagement than simply turning up and speaking at people. Engagement involves listening, compromising, collaborating.
I'm grateful to the Honourable Lady for giving way. She's making a very important contribution to the House, as she often does. And for me, it's not even about what's happening with withdrawal. Would she agree we can't even get discussions about the Shared Prosperity Fund and what's happening to that? We are 19 or 20 months from when the consultation should have taken place and ended. And I understand from Welsh Assembly member colleagues and Welsh Government colleagues that they can't even get a discussion with the Treasury, with BEIS, the Wales office, the Scottish office. So if we can't even get what happens to our funding right, there is little hope on having genuine consultation with devolved administrations on the process of leaving.
I mean, that is very much the experience of my Scottish Government colleagues across the board in this engagement which takes place with the British Government. And in fact, in a recent keynote speech to the Institute for Government, my friend and colleague Mike Russell, the Cabinet Secretary for the Constitution in the Scottish Government, said that at no point have the views of the Scottish Government or the Welsh Government or Northern Irish representatives been addressed in a way that has left him believing that he's been listened to and would be taken account of in any meaningful way. And still less has there been any recognition of any need to accommodate the pro-EU majority in Scotland, the pro-EU majority in Northern Ireland, and nor has the position of Scottish MPs, or indeed the Scottish Parliament, which normally votes by more than 2/3 to 1/3 on substantive Brexit issues. And indeed, just this afternoon, as we've been debating here, the Scottish Parliament has voted by 92 votes to 29 votes to withhold legislative consent to this withdrawal bill. So I'm afraid you can't blame just the bête noire of the Scottish National Party for that. It's involved all parties in the House, Lib Dems, Labour and, of course, the Greens, but not the Scottish Conservatives, who are not, of course, interested in what the majority of people living in Scotland want. They're more interested in doing the bidding of their Westminster-based masters. So really, the point is this, Mr Chair. There's been no meaningful engagement with the Scottish Government. There's been no meaningful engagement with the Welsh Government. As we heard even from the DUP, with their genuine right to be annoyed about recent developments, there's been no meaningful engagement with Northern Irish representatives over the peace. So while we hear a lot of rhetoric today, again and again, about how the British people have spoken and the will of the people, and a suggestion that we are somehow an affront to democracy, the opposition, for turning up and scrutinising this bill, it's important to remember that far from being an affront to democracy, those of us who speak for Scotland, myself and my honourable friends, we speak for majority opinion in Scotland. The majority opinion in Scotland is to remain in the European Union. Every electoral opportunity that has been afforded to Scotland since the EU referendum, and including the last general election, has resulted in a resounding majority of seats for parties who support remaining in the European Union. So can we just maybe tone down a wee bit the rhetoric about the will of the British people, and can we also maybe just acknowledge the reality about the degree to which engagement has taken place? And don't just take my word for it, or the word of my colleagues in the SNP Scottish Government. The Public Administration and Constitutional Affairs Committee of the Commons concluded in July 2018, it's clear from the evidence to this inquiry that Whitehall still operates extensively on the basis of a structure and culture which takes little account of the realities of devolution in the UK, and this is inimical to the principles of devolution and good governance in the UK. So that was the conclusion of a cross-party committee of this House. So again, Mr Chair, I don't expect any support on the government benches for SNP new Clause 8, but it gives me the opportunity to correct some factual misunderstandings about the degree of engagement that's taken place over the last few years. And linking into that, I'd just like, before I sit down, to express my support for new clauses 45 and 46, tabled by my colleagues in the SDLP. New clause 45 would require each devolved legislature to give legislative consent to any trade deal affecting the NHS. Now, that's very similar to the SNP's new clause 68, which has not been selected for debate. But what I really want to say here is the SNP manifesto in Scotland contained a commitment to protect the NHS from a trade deal with the United States of America. Now, we won the election in Scotland with 45% of the vote and 80% of the seats, and I think it would perhaps be a courtesy to try to take on board an amendment which reflects the will of the majority of people who bothered to vote in Scotland.
On that point, you would also acknowledge that a similar pledge has been made by the Welsh Health Minister, my constituency colleague Vaughan Gethin, and Welsh Labour's commitment on this, and I'm sure Plaid Cymru and others, is absolutely clear that we will defend the NHS in Wales in such trade negotiations.
I'm very grateful to the honourable gentleman for reminding me of the position in Wales, and of course that reflects the fact that, again, this is not just a concern of nationalist parties, it's also a concern of the parties who support the devolved settlements but perhaps don't wish to go as far as independence. And the SDLP's new clause 46 requires regional equality, environmental and economic impact assessments of any proposed future relationship or a free trade agreement. Again, eminently sensible, and it is similar, of course, to Plaid Cymru's new clause 16, which is looking for a UK-wide economic impact assessment. Again, matters which I thought any MP who cares about the outcome of these negotiations in the future on his constituents' livelihoods would be well advised to support. So, Mr Chairman, I would conclude by saying that we need to take account in these proceedings today of the different positions of the devolved nations. And what I would say, and what I will continue to say to the benches opposite, is if they continue to act as if there is no difference between the wish of the electorate in England and the wishes of the electorate in Scotland, Northern Ireland and Wales, then they will do so at their peril, and the union which they say they care about so much will be further undermined by that behaviour.
Layla Moran.
Thank you very much, Sir George. I rise to support new clauses 10 and 29, which we will be seeking a vote on today. And these should be no-brainers. These should absolutely be no-brainers. New clause 10 is about Erasmus, the Erasmus programme. For students, young people, those in training and staff who work in the education sector, the Erasmus scheme has been absolutely incredible. I wonder how many of us on these benches have either used that programme themselves or have had their children or others in their family do it. In Erasmus Plus, between 2014 and at the end of this year alone, €1 billion has been allocated to support the UK as part of this scheme. And all new clause 10 would do would be to require the government to do what it says it wants to do, but let's be sure, to seek to negotiate continuing full membership of the future Erasmus education and youth programme. Now, of course, access to this programme, we could secure it through negotiations, but we would be also an associated third country. It would never have been as good as the programme that we are part of now. But at least in new clause 10, it would be this Parliament instructing government that as part of the next phase, that is something that we absolutely want to see. Let's remind ourselves of what Erasmus does. It allows our young people to go abroad to European universities, to learn new languages, to meet new people, to put down some roots abroad, to build that international understanding that is, in my view, a big part of what it means to be British. I will, of course.
I can congratulate her on bringing that matter to the House for consideration. Just today I had the opportunity, Mr Chairman, to meet representatives from the Russell Group, which encompasses 24 universities across the whole of the United Kingdom, Great Britain and Northern Ireland. The Erasmus scheme is one of the schemes that they referred to. they intimated how strong, how good that scheme was and how important it was to have it in place and the opportunity that it brings forward. I'd just like to support the Honourable Lady on what she said and referred to that. And also, when we have universities with the capacity and the strength of membership we have across all the 4 regions, it would indicate to me that the Erasmus scheme is a good scheme and needs to be retained.
I thank him very much for his intervention, and I think he makes the point beautifully. This is something that, it is such a no-brainer. This is something that we should be wanting to keep. There is also an economic boost to, these people using the scheme and then coming back and applying those skills. It increases their chances of getting a job afterwards. It increases their confidence. It increases their sense of independence. And Brexit puts that all under threat. I should also add that if full access to that scheme isn't negotiated, we must remember that it's those from the poorer families that will suffer. Those who come from well-off families will be able to go and study abroad if they want to. Their parents would be able to pay the fees if they wanted to do that. It's the Erasmus scheme that gives those from poorer backgrounds that ability to do that in a way that simply wasn't available before that scheme came to fruition. I will, of course.
Erasmus Plus and the reasons why we should keep it. But is she aware that Pollock Shields Primary in my constituency is one of the very few state primary schools that participates in the exchange programme and broadens the horizons from children of a Scottish Pakistani background to twin with a school, Colegio Hernandez from Spain. So our horizons are being broadened in all kinds of different ways under this scheme, and it would be such a shame to lose it.
I thank her very much. Again, this is another reason why we need to keep it. And I'll simply say this. Whilst Brexit does suggest to those abroad that Britain might be not quite as international facing as it was before, every time I meet a young person, and particularly in that last election, it was things like Erasmus that they pointed to as the older generation pulling up the drawbridge to the opportunities that we had that they wished that they had for their futures. And I think it would be such a shame for us to conclude this debate this week without a firm assurance from the government that they want to keep that programme and that there would be nothing that they would love more than to see this written in the bill itself. I don't understand why you wouldn't want to do that. And the same actually goes to Horizon 2020. I will broaden it slightly because, this idea of productivity, we know this productivity gap is one of the biggest crises in our country. And Horizon 2020, that we also speak about, is another example of the best of European cooperation. Over the period of 2007 to 2013, the UK received 8.8 billion euros on research and development and innovation from the EU. But I will point out, because I've heard the government from dispatch boxes over the last few years when I've raised this, say we will replace the money. And I will make the point through the voice actually of a constituent of mine who's a professor of chemistry at Oxford University, and I hope we will concede he probably knows, that it's not just about the money. He says it's important for ministers to recognise that access to EU funding only plays a part and is certainly not the full sum of UK scientists' concerns. Science is indeed Humboldt's country without borders. In 2018, over half of all scientific research papers published from the UK acknowledged international collaboration through author addresses, and well over 30% of all publications involved one or more other EU country. I think that, again, says it all. I hear it over and over again. If we want to attract the best, a visa isn't going to help. They need to know that they will be absolutely welcome in our country, and they are welcome for those research opportunities. We are already seeing it in our institutions, not just Oxford, University of Oxford, Brookes as well, and the number of professors and others who are coming to me and saying, I tried to put in for a certain grant, it's not being accepted anymore because of the uncertainty that this is causing. Again, having this as part of this bill would give them the certainty they need to be part of that collaboration from now. And believe me, when those people go and they go to the other European universities that will have them, that's where they put down roots and that's where they're more likely to stay. We can't afford to lose these. The best and the brightest is one of the things I know this government wants to keep. Well, these are them, and they're saying that they are leaving. And finally, I will also speak to new clause 29, which is about that level playing field. Now, I will obviously be supporting the Labour frontbenchers' vote when it comes, because that level playing field and how it affects workers' rights is incredibly important. But I will continue to press that it's not just workers' rights. It's also about environmental standards as well. And that's the bit that I am seriously concerned about. If there was the best part, in my view, of this election that we've just had was the way that environment was at the top of the agenda. For all political parties, apparently, we kept hearing during the election from the government that they wanted to supersede the level playing field arrangements when it came to environmental standards. And that's brilliant. So the level playing field, all it is, actually, is a minimum standard. Why would we not want to keep it? Same goes for workers' rights. Same goes for anything else when it comes to that level playing field. The problem is, we'd heard before that by removing it, by deregulating, that it opens the door to lower standards. We talk about America, but it's not just America, but let's face it, we know that that's where the government is looking to its next trade deal. And I just want to be clear about what the problem is. The Environment Bill, which they say is going to replace this, doesn't operate on the stronger precautionary principle that the EU's environmental standards currently operate to. We are in a climate emergency. We can't help but be moved, I'm sure all of us, by the images coming out of Australia. We need to make sure that these minimum standards are the absolute minimum. And my worry is that in a post-Brexit world, we are looking for trade deals with other countries who would much prefer it if we lowered our standards, that would open the door to us compromising in an area where I heard time and time again there was no appetite across the country for any kind of compromise. I will, of course.
I'm grateful to her for giving way. She's making a very powerful case. Would she agree that non-regression is vital, but also the dynamic alignment is vital too, because these EU legislation is constantly modified. The REACH legislation, for example, has been updated 38 times since it first came into power in 2006. So if we're to avoid the risk of so-called zombie legislation, in other words, EU legislation that's been brought across to the EU, to the UK statute book, but isn't being updated, then we need to have that dynamic alignment as well.
Absolutely. I thank her very much for her point and commend her on the work that she's done so tirelessly on this as well. I think there is broad consensus in this House now that we must take the environmental crisis seriously. And as the science progresses, as we understand where the technologies are going, we must stay close to our nearest neighbours, and that matters when it comes to the environment, it matters when it comes to biodiversity, and we have to make sure that we do that. So I ask you all to consider, as a sign to those who want to make sure that we stay within that level playing field and stay within these programmes like Horizon and Erasmus, to vote for new clauses 10 and 29. Thank you.
Debbie Abrahams.
Thank you, Sir George, and it's lovely to see you in the chair there. I'm rising to move my new clause 27, which seeks to ensure that there's no regression from EU standards on environment, food, on the substance of REACH regulations, which seek to protect human health and the environment from the use of chemicals, and also in terms of animal welfare. So just the points that have been made. The UK currently enjoys high standards in areas such as habitat protection and product safety. Having developed these standards with our European neighbours, we now benefit from cleaner beaches, safer food, and the best chemicals regulation in the world. The government is committed to legislate to ensure that high standards of environmental protection to ensure high standards of environmental protection, but hasn't yet delivered on this commitment. The 2018 Withdrawal Agreement contained a legally binding mutual commitment to non-regression in areas of environmental law if the transition period did not produce an agreement on the future relationship. This has been removed from this bill, and I wonder if the Minister can explain this. Sir George, climate change is the defining issue of our time, and we are at a defining moment. The world is now experiencing a climate emergency, and an urgent and rapid global response is now necessary. From shifting weather patterns that threaten food production to rising sea levels that increase the risk of catastrophic flooding, and of course the horrendous fires, bushfires that we're seeing in Australia. The impacts of climate change are global in scope and unprecedented in scale. After more than a century and a half of industrialisation, deforestation and large-scale agriculture, quantities of greenhouse gases in the atmosphere have risen to record levels that have not been seen in 3 million years. We know that as populations, economies and standards of living grow, so does the cumulative level of greenhouse gas emissions. In October 2018, the IPCC issued a special report on the impacts of global warming of 1.5 degrees, finding that limiting global warming to 1.5 degrees would require rapid, far-reaching and unprecedented changes in all aspects of society. The IPCC said we must cut global emissions in half by 2030 and achieve net zero emissions by 2050. The UK should be leading both nationally and internationally, and the government must play their role. Yes, of course.
I'm grateful to her for giving way. She won't be surprised that I completely agree with what she's saying, but she'll know that the Prime Minister has said that he wants to bring forward what he's called the most ambitious environmental programme of any country in the world. That being the case, does she share my bewilderment that ministers could even be conceiving of not supporting this amendment? And what would they have to fear from an amendment that simply seeks to make sure that we don't actually go backwards if they're absolutely serious about delivering on the environment?
Absolutely. My honourable friend makes absolutely the point that I'm trying to make. If the government is committed to doing this, then why aren't they actually putting it on the face of this bill? Last September's UN Climate Action Summit delivered a boost in momentum, cooperation and ambition. But as the UN Secretary-General said, we have a long way to go. We need more concrete plans, more ambition from countries and more businesses. We need all financial institutions, public and private, to choose once and for all the green economy. This year's UN Climate Conference must see existing commitments renewed and increased, not least by this government. The political declaration agreed by the UK and EU in October 2019 proposed that the UK and EU should uphold common high standards. However, the declaration is only indicative and is not legally binding. Including an amendment on environmental non-regression in this bill would help ensure standards are not weakened during the process of EU withdrawal across the UK. Given the scope of this bill, and it's focused on actions in connection with the EU withdrawal, further non-regression guarantees will be needed both in domestic legislation, such as the Environment Bill, and in the future relationship agreement with the EU. So the new clause is broken down into a number of different groupings. So clause 14A defines regressive and protected matters covered by the amendment. First of all, regarding environment, then food safety and other standards, the substance of REACH regulations, and then finally animal welfare. Clause 14B adds a procedural check similar to that already carried out on new legislation in relation to human rights for primary legislation. This requires government to either state that new legislation does not weaken environmental standards, or if it does, to explain why it does so and require explicit parliamentary approval of that regression. The new Office for Environmental Protection must be consulted during this process. Clause 14C prevents withdrawal from the EU being used as a route for lowering environmental standards by secondary legislation. And Clause 14D prevents withdrawal from the EU being used as a route for lowering environmental standards by other public body action. Clause 14E requires the Secretary of State to publish guidance for environmental departments and other public authorities to support them avoid any regressive actions. And finally, Clause 14F ensures that all new environmental law is reviewed by an expert independent body to track potential divergence. If any potential divergence is identified and not approved by Parliament, then the government must commit to taking steps to rectify that divergence. An argument has been made that this amendment is not needed as the UK will have better standards going forward. However, government ministers have stated many times that environmental standards will not be weakened, so it should not be controversial to guarantee this in legislation. This is what my honourable friend has just mentioned. So what can be the objection that the government has to committing to this new clause? I would very much welcome the minister's comments. A meaningful commitment to non-regression is essential if the UK is to genuinely put itself forward as a world leader in environmental protection. I urge the government to support this new clause. We need to ensure that deeds match the words that the government has said. Finally, Sir George, if I may mention how disappointed I was that new clause 9 of mine, which I sought to prevent any Minister of the Crown from financially benefiting from any proposed trade deal, was not selected for debate. I was under no illusion that the government would support this, but I wanted to highlight this issue. If anybody hasn't read the excellent book by Professor Danny Dorling on what is actually driving Brexit, I would thoroughly recommend it. If national policy is being driven by the narrow interests of a few, and their interest is about their own enrichment, our politics is not just damaged, it's broken. Politics, I'm sure many of us here would agree with this, but politics is about public service, not what politics could do for us personally. Thank you, Sir George.
Claire Hannah.
Thank you very much, Mr Deputy Speaker. I rise to move amendments NC 45 on protection of the NHS from any future trade deal and NC 59 on ensuring political representation for Northern Ireland in the EU Parliament. I suspect that it goes without saying that I deeply regret the arrival at this point in the Brexit process. We still view Brexit as an extraordinary act of self-harm for Britain, and one which, of course, we on our side of the Irish Sea will suffer immense political and social and economic collateral damage. And in order to protect ourselves, and indeed yourselves from that, my Social Democratic and Labour Party colleague and I tabled a number of amendments around impact assessments, around non-diminution of rights, which the member from North Down expanded on very well, and around giving flexibility to the Good Friday Agreement institutions to respond to some of the challenges that Brexit is going to bring for us. I don't think I need to remind members that the Good Friday Agreement is sovereign in Northern Ireland. It has been endorsed by the people overwhelmingly, more than anything else before or since, and it isn't just an ornament to have on the mantelpiece. It's a toolkit that can help us weather the storm of Brexit, but it has to be given the powers and the flexibility and the opportunity to respond to many challenges that we know are coming, but that we don't quite know the shape of yet. And indeed, ensuring European parliamentary representation for Northern Ireland is part of that, because we will thankfully be within the regulatory orbit of the EU, and the Good Friday Agreement, members will know, provides and mandates the government to ensure that there's no diminution of rights for people in Northern Ireland because of Brexit. And one of those rights as Irish citizens, and therefore as continuing EU citizens, is the right to political representation in the EU Parliament. So we believe there's a duty on this government to continue to provide that right for continuing EU and Irish citizens. In many ways, it mirrors amendments made by others about democratic oversight and transparency, and indeed parliamentary consent as this Brexit evolves, and for the very many reasons that members have laid out. If Brexit is going to deliver even a fraction of what the members on the benches opposite are promising, they should have no concerns about oversight and about allowing people to see this as it evolves. I have always found in matters of public policy that sunlight is the best disinfectant. Allow people to see how processes are happening. New clause 45, I believe, is fairly self-explanatory. It seeks to ensure both that the National Health Service is protected from any future trade deals, and also that if any future relationship affects the devolution settlement regarding health, that legislative consent is sought from the Northern Ireland Assembly, and fingers crossed it will exist again next week, and also from the Scottish Parliament and the National Assembly for Wales. Colleagues, we also tabled a number of other amendments and support amendments that mirror those on the level playing field, on maintenance of workers' rights, on Erasmus and Horizon 2020, which is so fundamental indeed to the Queen's University in my own constituency of South Belfast, and indeed safeguarding for EU nationals that live here. Yes, I'd be happy to.
Thank you for giving way. Just making some very pertinent points for this debate that we're having. In my constituency, the agri-food sector is so important for jobs. They need to have the workers' rights enshrined so that those who are very involved in the agri-food sector in my constituency have their jobs retained, first of all, have their immigration status retained. There may be some cases where some people may fall through the cracks. And if that's the case, we need to ensure that they, even at this late stage, can still apply and have the status that they need. Does the Honourable Lady feel that perhaps government should enshrine in legislation something that enables those people to retain their immigration status here in the United Kingdom, Great Britain and Northern Ireland, so that they can then help our agri-food sector to grow and to do even more and provide more jobs?
I do indeed agree, and was surprised to find myself in the same lobby as the member a number of times today, because that's how important these issues are to protecting jobs, protecting consumers, protecting our economy. Because actually, you and I come from a place that has an immigration problem, and that immigration problem is young people feeling the need to leave for opportunities. And the fact that we have EU workers coming, making their lives where we live, paying their taxes where we live, contributes, enriches our economy, enriches our community and cultural lives, and absolutely everything must be done to protect those who are feeling the costs already of Brexit. We spoke earlier about the economic impact, but I've spoken to people already, EU citizens who live in my constituency, who are already feeling a chill, who are already maybe being passed over for jobs or for promotion because their employer doesn't know, are you going to be allowed to work here next year, or am I going to have to fill in lots of forms to employ you? As I say, we've covered such an array of issues, all of those that I've mentioned that have been very well laid out by a number of members, including child refugees. Members, that's children who are refugees. You know, the members opposite are in many ways, and I mean that's not as an insult, the dog who caught the car. You've been chasing Brexit for a very long time. You now have it. You have the numbers to get it done, and with that comes a duty to protect people from Brexit. I don't believe there's any good way to do Brexit, but you do have the numbers and you do have the duty to take the very rough edges off for the most vulnerable people.
David Linden.
Thank you very much, Sir George. It's an honour to follow the Honourable Lady from Belfast South. Much of what she said I agreed with. I refer members to my new clause 56 on the implementation period negotiate objectives annual celebration of Europe Day. Unfortunately, it has not been selected by the acting chairman of Ways and Means, but I do think it's important to. I see the Minister chuntering, which is unusual for him. But I think it's important. I think it's important that as members of the European Research Group, in their infinite wisdom, talk about Big Ben chiming away on the 31st of January, that the Minister and the government, if they are serious about a strong future relationship with the European Union, do very much consider our suggestion of an oral statement to be made during Europe Day, and for European flags to be flown above government buildings between each. I'm very happy to give way to my honourable friend.
Thank him for giving way so early, and he makes a good point there. His new clause is about celebration and recognising what we had in Europe versus the triumphant attitude of the ERG and the Brexiteers talking about sounding Big Ben on January 31st. I was contacted by constituent Paul from Kilmarnock, who requested the government does not do a triumphant celebration on January 31st because of the despair so many other people feel because of what they're losing. We need to recognise what will EU citizens feel like on that night when we exit Europe and they're wanting Big Ben sounding. Does my honourable friend agree?
Yeah, absolutely.
Well said.
Very grateful indeed to my honourable friend from Kilmarnock and Loudon for that intervention, and I think that his constituent Paul makes a fair point. And I think that when we go forward with Brexit, this isn't about the kind of narrow nationalism of the European Research Group and this kind of inward-looking little Britain attitude. And actually, the suggestion in my new clause 56 is a way of expressing a more outward-looking view about the future relationship. So I'm sure that when the bill goes to the other place, perhaps the government could bring forward an amendment to that respect. But I do want to stay in order, so I rise to speak in favour of new clause 8 in the name of my right honourable friend from Ross, Skye and Lochaber, and to speak to new clauses 50 and 51, as well as new schedule 1 in the name of my honourable learned friend from Edinburgh South West. Now, I won't detain the House for too long this evening, but I'll confine my remarks to the amendments specifically on membership of the single market and customs union, and after that I shall move to workers' rights. But before I do go further, I think it's important to reflect on the new reality of where we're at following the general election. Like it or not, the Conservatives must accept that their Brexit message failed in Scotland. They lost more than half of their seats, and the SNP now holds 80% of Scottish seats in this House. And in the most undemocratic manner possible, the Tories are simply choosing to ignore Scottish voters by pressing ahead with their hard Brexit plans. Sir George, put simply, we are being dictated to by a minority party in Scotland. Hear, hear. And during the general election campaign, one of the Prime Minister's more bizarre media stunts saw him drive a JCB digger through a polystyrene wall to deliver his Get Brexit Done message. Now, Mr Howarth, it's very clear now that that wall represents Scotland, and this Tory government intends to force ahead with their bulldozer Brexit. And like so many people in Scotland, I distinctly remember leaflets being delivered during the Scottish independence referendum campaign imploring people that a no vote was a vote to protect our rights as EU citizens and to maintain our membership of the European Union. And understandably, and even though it wasn't how I voted, many of our fellow citizens voted no in good faith that this truly was the best way of protecting our EU membership. And 5 years on, having voted to stay in the United Kingdom, the people of Scotland now face the harsh and sad reality of our country being dragged out of the European Union by a British government we did not vote for, and by an intransigent Prime Minister who has no mandate from Scotland for this utterly reckless move. Hear, hear. And early on, following the Brexit result, the Scottish Government sought to compromise with the British Government to ensure that if Brexit was indeed to be pursued, then it would be done so in a way that would cause as little economic damage as possible for our nation and its people. And for those of us who closely followed the consequences of the 2014 referendum, an expectation of compromise and respect was perhaps not an unrealistic ask. And if we voted no, we were promised in 2014 that Scotland wouldn't just be treated equally and with respect. Indeed, we were told that we would lead the United Kingdom. So somewhat naively, when the First Minister of Scotland outlined a compromise position which would see Scotland remain in the single market and the customs union, many people thought that this would be considered in good faith by the British Government. And my honourable friend from Edinburgh South West has already outlined the document Scotland's place in Europe from 2016. And so we asked for that compromise and that goodwill to be considered, but it was not. We were told that it was impossible. So imagine our surprise when this Prime Minister came to power and negotiated an amendment to the Withdrawal Agreement which sees Northern Ireland have unfettered access to the single market and customs union, unquestionably putting Scotland at a competitive economic disadvantage. And what we see in its starkest terms is an unequal and broken United Kingdom, with Scotland being left out in the cold. Every other nation in the UK other than Scotland gets compromise or what it voted for. Northern Ireland, which voted to remain, gets access to the single market and the customs union. England, which voted for Brexit, gets Brexit. Wales, which voted for Brexit, gets Brexit. But Scotland, which voted to remain, gets economically trashed and utterly ignored. And so New Clause 8 is a last-ditch attempt from the SNP to make the British Government see sense and protect Scotland from the inevitable job losses of leaving the single market and customs union. The cost of leaving the single market and customs union is just too high to contemplate for Scotland. And put simply, it means up to 100,000 jobs being lost, thousands in my own fragile constituency of Glasgow East. So I implore honourable members opposite, particularly those from Scotland who claim to come here and stand up for Scotland, to support New Clause 8 in the name of my right honourable friend. And I'm looking around the chamber tonight. I don't actually see any Conservative members from Scotland, but perhaps that won't be a surprise. I wish to turn now to New Clause 51, which seeks to protect workers' rights. Because quite simply, the British Conservative Government cannot be trusted with workers' rights. Let us never forget, theirs is the government which brought forward the draconian Anti-Trade Union Act. Quite simply, trusting the Tories with workers' rights is akin to putting a lion in charge of an abattoir. Because we know what they already think. It's on public record. Take, for example, the current Foreign Secretary, the Right Honourable Member for Esher and Walton. He has been attacking workers' rights ever since he became an MP in 2010. 9 years ago, he wrote a research paper calling for, and I quote, a total opt-out from the Working Time Directive. Even though the Working Time Directive ensures millions of workers have the right to paid holidays, time off work and guaranteed lunch and rest breaks, the current Foreign Secretary singled it out as one of 10 obstacles to British business. His paper, entitled Escaping the Straitjacket, also urged the UK Government to ensure that this, quote, costly anti-jobs legislation cannot cause further damage to the economy. Very happy to give way to the Honourable Gentleman.
I thank the Honourable Gentleman for giving way. Isn't the principle, though, whether it be on workers' rights or indeed on anything else, that this House will be the place where the decisions on those issues will be legislated upon? And so, look, of course, there are political differences on all sorts of issues. I happen to take issue with the way he characterises them, but that's beside the point. However, this House will decide what the workers' rights for UK citizens should be. Surely that is the aim of this House.
To the Honourable Gentleman from Mitchin and Harpenden for that intervention, but that is that's my concern. We have a Tory majority government that will morph into Thatcherism and steroids over the course of the next 5 years. Yep. And so for me, the idea that we'll just sit back and let the Prime Minister and the current Foreign Secretary dictate which direction we take with employment rights is not a chance that I'm willing to take. My honourable friend from Glasgow South West, of course.
Well, I thank my honourable friend for giving way. But isn't the reality is in the last 20 years, the advances in workers' rights have mainly come from Europe? When you look at the Fixed Term Workers Directive for those in temporary contracts or for those who are part-time in agency work, that it was not this place who was advancing the cause for those workers. It was the European Union and the European Parliament.
Absolutely, and I think it's for that very reason that 62% of people in our nation voted to remain in the European Union and did not want to see the control of workers' rights being somehow controlled from London. But I want to go back to what I was saying about the Right Honourable Gentleman, the member for Esher and Walton, in his remarks about the Working Time Directive and some of those obstacles that he identified in relation to British businesses. The fact that he did so in an article calling for a renegotiation of the UK's future relationship with the European Union doesn't bode well now that he's in one of the highest offices of government. And our hard-won workers' rights secured from 40 years of EU membership cannot be forgotten, diluted or even abolished by this right-wing neoliberal government that Scotland did not vote for. Therefore, I urge honourable members to support new clause 51. But let's be honest, we know the results of tonight's division before they even take place. And I think we need to face the truth. There is, of course, a majority Brexiteer government which thinks Scottish voters will simply lie down while they steamroll over their interests. So the choice for the people of Scotland could not be clearer, because Scotland does unquestionably have the right to choose its own future. Do we stay shackled to Brexit Britain and failed Tory economics, or do we rejoin the family of European nations which is outward-looking, progressive and treats its member states with respect, dignity and equality? And of course, the Tories often accuse the SNP of trying to break up Britain, but the reality is it's them who are driving the bulldozer. Make no mistake, the Scottish independence referendum is coming, and the passage of this legislation tomorrow will doubtless result in people taking a very different view than they did in 2014.
I'm very grateful to George for being able to make what will be a very brief contribution to the debate this evening, and to follow the honourable gentleman for Glasgow East, who reminded me of the debates we've been having over the last 3.5 years in this House since the referendum. There was an overwhelming sense of déjà vu that some members of this chamber who supported the Remain position at the referendum have still not recognised properly that time has moved on. I was one of those who voted Remain in the referendum in 2016, and I, in common with many colleagues across this side of the House, are reconciled to the fact that the British public voted to leave, as demonstrated very forcefully in the general election that we've just gone through. So the déjà vu that I'm experiencing is that many of the arguments that we've heard ad nauseam for hours and days and weeks in this chamber are still being trotted out again in this debate today. The reason I have stood, I'm just going to make a small progress, if I may, is that it was a debate on the EU in which I participated in for my maiden speech on the day that, in the first month that I arrived in this House 14.5 years ago, and therefore I think it's fitting that I should say something in this debate just before we hopefully cease debating whether or not we are leaving the EU at the end of this month, because that matter has now been resolved, and I wanted to make a specific contribution in relation to the new clause 27 introduced by the Honourable Lady for Oldham East and Saddleworth. The spirit and principles behind, underlying the new clause, which she spoke eloquently on earlier, I have very considerable sympathy with. But the reason I wanted to make reference to that new clause is really to ask the Minister in his summing up before we leave the committee stage this evening as to how the government intends to take account of the spirit and the intent underlying that new clause in future legislation. Because I recognise that the Withdrawal Agreement Bill is not the place to adorn legislation with commitments which have nothing to do with the Withdrawal Agreement Bill per se, but are nonetheless worthy in themselves. And I'm going to draw to the attention of the House a clause in the Conservative Manifesto on which I was proud to stand very recently, which says, "We will legislate to ensure high standards of workers' rights, environmental protection and consumers' rights." We've already heard from others this evening about the existing higher level of workers' rights that apply in the UK over and above those that are applied across the EU. And we as a government have an ambition to maintain environmental protections in many areas as a higher level than currently apply across the EU. I have to give way.
To the Honourable Member. And this isn't meant to sound trite, but there were a number of different commitments that were made in different manifestos. So, for example, I could mention the commitment to halve the disability employment gap. In the 2015 manifesto, I could mention the commitment for new starter homes, neither of which were delivered. This is about backing up. If you are seriously committed, and I understand the Honourable Member certainly is, if you're seriously committed to that, what is wrong with putting this on the face of the bill?
Well, I'll give one example of what is wrong with the clause that she's drafted, and that is its territorial jurisdiction. Environmental protection, I'll remind her, is primarily a devolved matter. And in relation to the environmental bill that will be brought before this House and was in the Queen's speech, the territorial jurisdiction of such a bill will be primarily to England and to a small extent to Northern Ireland. And I'm rather surprised that the honourable members representing the Scottish National Party, who are here in force this evening and have been speaking just before me, didn't choose to raise that point.
Thank you for giving way, and it's great to hear that he's such a great defender of devolution. So, as a defender of devolution, does he respect the fact the Scottish Parliament rejected the UK Government's legislative consent motion today, and does he also respect it's the right of Scotland's people to choose their future?
Well, as the Prime Minister said far more eloquently than I at Prime Minister's questions earlier today, the Scottish people did decide in 2014, and that's the vote that should be respected by this House. I'm going to, Sir George, move back to my point rather than engage in... No, I'm not going to take his intervention because I know what he's going to say. I'd just like to conclude my remarks by asking the Minister, if he has the opportunity in his winding up speech, to refer to the environmental bill that will be brought before this House shortly, and to what extent are the protections that are being sought through new Clause 7 likely to be enshrined in that bill?
I'm now going to call the Minister to respond to the debate, James Dudridge.
Sir George, thank you. And it's always a pleasure to follow the Honourable Member for Ludlow, and I think throughout my contribution I'll be able to reassure him, particularly on non-regression issues. We've had a number of good speeches, and I actually sense over the last few days since the general election a change in tone in the Parliament and acceptance of that which is happening, and actually a better debate across houses relating to what is actually going to happen. There is a little bit of laughter or chuntering, as the Honourable Member for Glasgow East would call it, something that I've been an offender of as well, but I do genuinely sense a small change in tone. I would like Sir George to speak to 21 new clauses clauses, I'll focus my time, because I understand the House want to progress on the substance of the amendments rather than the ones that are technically flawed, because broadly speaking, and this point has been made a number of times, specifically that they're probing amendments, but hopefully there are a few more that are more probing than substantive that are wanting to be pushed to a vote. So I'd first like to speak to New Clause 2 and New Clause 51 as Schedule 1, tabled both by the official opposition and the Honourable and Learned Member for Edinburgh South West, who's been omnipresent throughout today, and I'm grateful for those contributions. These amendments relate to the protection of workers' rights. As the Government stated, and the Prime Minister has confirmed, and we talked about, we are committed to ensuring that workers' rights are protected as the UK leaves the EU. And I want to reiterate that and add some detail to that. There's no suggestion that this government would propose or this Parliament would allow a change or regression in workers' rights to make them lower than is currently required by EU law. We have been clear, in fact, that we will protect and continue to improve workers' rights. And these amendments are not required, don't require us to leave the EU to protect. We can do that on our own. I certainly give way to the Honourable Member to save him chuntering at me.
Grateful to the Minister for allowing me to chunter on the record. The Minister, of course, is talking about workers' rights and what the Government's going to do. We understand that if we're to believe the promises of the Government, that will be coming by way of the Employment Bill. Can you tell us when the Employment Bill will be presented to the House and when it will be published?
Well, it is very soon after the Queen's speech, and that timetable will come through the normal channels in the normal way. I'm afraid I can't give him any notice. If I do get an inkling of when it's going to come, I'll be sure to tell him in the coming period as soon as I can. And as he's pointed out, we have announced in the Queen's speech we'll be bringing forward legislation, and this will deliver on the work of the Good Work Plan and the Taylor review. This will also give workers in the UK the protections that they need in a changing world. I think there's an increased recognition that the world of work is changing. I certainly give way.
I'm very grateful to the Minister for giving way, and isn't that precisely the point, that it's for this chamber and this sovereign parliament to pass the laws? And indeed, he's mentioned the forthcoming bill that will be produced in due course. It will be this chamber, this House of Commons, that determines the appropriate rights, the enhanced rights that we already enjoy. We don't need to be a member of the European Union in order to have those rights.
The Honourable Gentleman for his contribution succinctly made. He's entirely right. We will have the freedoms to determine our future on this issue, to give the best. I'm going to make a tiny bit of progress and I'll give way to the Honourable Gentleman. New Clause 2 would require the UK to negotiate to become effectively a rule taker in perpetuity, would be subject to EU employment rules with little or no influence over how these are actually developed. And the type of alignment envisaged by this amendment is unnecessary to maintain the high standards and protection for UK workers. This Parliament has set higher standards than many of the EU directives. For example, the UK's race and sex discrimination protection, equal pay, were all decided before we entered the EU. I will give way, with your permission, to Majesty's Official Opposition first.
I'm very grateful to the Minister for giving way. I just want him to clarify what he's actually said there about dynamic alignment. Is he actually saying that if rights were to be enhanced by the European Union, it isn't the government's intention to follow?
No, that's not what I said or the intention, but it is for this Parliament to decide what it wants to do, not to simply follow what an outside body recommends. I give way to the Honourable Gentleman.
This is the point. Firstly, I was not going to withhold consent to an intervention now. But can I seriously ask him? He mentioned the Taylor Review. Now, the European Parliament and European Commission are actually debating similar issues and will offer something that's stronger than what the government proposed in the Taylor Review. So can I ask him, if the European Parliament goes further than what the UK government is going on in terms of the Taylor Review, will it be the aim of the UK government to match to at least match what comes from the European Union.
Yes.
Good.
I'm actually going to go on later on in my speech to highlight areas where we are going to go further. So perhaps I'll give way to him again if he doesn't think that has given significant reassurance. So the government are committed to delivering high standards. And as I say, I'll come on other clauses and provide a bit more detail. I just want to move on now to new clauses 3, 8 and 30, and I thank the confirmation on new clause 8 that it is just a probing moment, which relates to alignment or continued membership to the EU single market and customs union. The Prime Minister has set out a deal, and that's in the political declaration, a framework for a comprehensive and ambitious free trade agreement, and the result of the general election has shown the public supports that across the whole of the United Kingdom, notwithstanding the points made in the Chamber today about different areas. That mandate did not include negotiating the customs union or maintaining the UK's place in the single market as proposed by this amendment. The public, I think, now wants to move on and get on to negotiating the future relationship without any unnecessary hurdles, and that is what the government will do. It's only by leaving the EU customs union single market that the UK will be able to pursue an ambitious and free trade agreement and strike new trade deals with new global partners and existing partners across the world. And it is the political declaration that provides a framework for all of this. It will also provide a framework in the political declaration, as already done, on security cooperation, which will include access to the European arrest warrant, which a number of colleagues have mentioned, to Europol and SIS2. So both we have committed to being involved in those, and our European partners have committed to engaging through the political declaration in that. We've also agreed to put in place a streamlined extradition arrangement and continue to work with Europol and Eurojust in that regard. And we've also agreed to look at further areas of cooperation beyond that, on the exchange of information, on the broader point the Honourable Gentleman's raised, and beyond SIS2 that would also include APPROX. The detail, though, means that this is best done in cooperation over the period at the right time. That is, after all, the point of the level playing field, to do this in a paced way. But I myself, as the cross-cutting minister, have engaged in this issue. A number of ministers have already engaged much more directly. And I think as this issue rolls out, the Honourable Gentleman will be reassured. But that's not really for today in the Withdrawal Agreement bill, although it is perfectly acceptable as a placeholder for the probing amendment. Moving to new clause 29. We want to be clear, we want an ambitious future economic partnership with the EU that allows us to control our own laws and benefits from trade with other countries around the world. And adopting this amendment, Sir George, would prevent that. We do not believe that dynamic alignment with the future EU rules is in the best interests of this country. It is here and not in Brussels where the decisions should be made over laws that are taken and governing our country, points that have been ably made elsewhere in this chamber. We will maintain and uphold the high standards of workers, consumers and the environment. We don't have to follow EU rules to achieve this. We can do it on our own. We have made it clear in the revised political declaration and through our commitments to bring legislation that will enshrine these high standards in our laws. And I'm more than happy to give way, and I'm coming back on non-regression in a bit more detail, but this young try to give way.
I apologise to the Minister, but I'm grateful for him taking the intervention. So can he confirm, as his honourable friend mentioned before, that the principles of my clause will be included in a new environment bill if they're not going to be included in this bill?
Forgive me if I'm not definitive, because I've not ticked off every single point, but the underlying point, there will be no regression. We're committed to environmental rights, and slightly later on I'm going to go into more detail in how we're going to go ahead of what the EU are currently do and what they are proposing to do. So in the spirit, yes, but I don't want to give a resounding yes just in case there's one comma in one part of her amendment that there's some deviance between what we're doing. I've just finished this point, and I'll give way to the Honourable Gentleman before moving on to the Erasmus programme. With regards to broader suggestions about participation in EU funding programmes, the political declaration envisages close cooperation across a range of areas, including science, which we're coming onto, and education. And it already provides the possibility for programmes, and that will be done during the negotiation period. The political declaration sets out that the parties will also explore the cooperation of the United Kingdom with all the other EU appropriate agencies, and the nature of this cooperation will be subject to the negotiations. I will go into a bit more detail. I promised to give way before, sorry, to the honourable gentleman. Apologies.
Thank Minster for giving way. It's said that don't need to be in the EU to protect environment standards. Now, I know from my experience as a young civil engineer, it was the EU threatening to take the UK and a Tory government to court that actually forced action to clean up our bathing beaches across the UK. It was purely being a member of the EU, or else there still be raw sewage going in our seas right round the waters of the UK.
I thank the honourable gentleman for that contribution. I'm going to come on a bit more to the environment. If I don't answer his underlying points, then feel free to intervene again. But I will come to Erasmus and then Horizon. It's good to see the member for Oxford West and Abingdon in her place, who has spoken to new clause 10. And this seeks to ensure, I'll come back, but I'm trying to move on to Erasmus. I'll either take an intervention on Erasmus at the end of the Erasmus or at a local point. So the government secured agreement during the implementation period to participate in all elements of the Erasmus Plus programme, and that will be done in the future relationship. We've made it clear that we're open to maintaining cooperation and expanding cooperation in education. We strongly believe, as she does, in the value of international, not just European, exchange, and it is very much part of our vision for global Britain, so extending the concept, not simply looking at the narrow area of the United Kingdom. And we believe that the UK and European countries should continue to give young people and students the opportunities around the world in universities and elsewhere, other elements of Erasmus and the lower area of sport post-Brexit. And the political declaration envisaged the possibility of the UK participation in EU programmes, and we will negotiate the general terms of participation where appropriate throughout the period of the implementation period. Ultimately, decisions about our participation will be a matter for wider negotiations, but we will look at all the available operations. Turning now to new clause. Would the honourable gentleman still like to?
Be grateful for the Minister for coming back to me. He mentioned EU funding programmes. Scotland currently benefits from €872 million over the past 7 years of EU funding. In the Highlands and Islands, that is a net benefit, a net contribution benefit to the Highlands and Islands, and has changed communities across our entire area. Does he have any idea, can he give us any inkling of when the Shared Prosperity Fund is going to be launched and what it will cover? Can he give us any information on that at all?
And the honourable gentleman makes a really important point. I will answer a specific question, but on a broader arena, we will be taking back control of our money and spending that as we choose, so we can. On his specific point, those decisions will come after a cross-governmental spending review, and I'm more than happy to commit the Treasury to write to him with any more detail if it is available. Moving now to new clauses 16 and new clause 46 on economic assessment in the name of the SDLP. This would require environmental and equality impact assessments. There are quite a few impact assessment calls across the board, and I've been making the point a number of times around the cost of these. You know, in some cases we're already making commitments, and would be bad government spend, and for the sake of it, producing a report. But this debate is about the Withdrawal Agreement bill and exiting from the European Union. A lot of these reports are about the future relationship. It would be an inappropriate place to put those reports, even if it was the right thing to do. And it simply wouldn't be possible to agree to publish a detailed analysis of something that hasn't yet been Agreed. In November 2019, the government published a detailed analysis that covered a broad range of...
So, a great discourtesy for people to be carrying on separate conversations during the course of any member of the House while they're speaking. Minister.
Thank you. I suspect the House is encouraging me to make progress, which I will take the hint. But please do bear with me. These are 21 new clauses, and I think it's quite important to cover them off. They've all been put down very seriously and deserve the attention of the government. Turning to new clause 38, the government's committed to producing and publishing an objective spending analysis of the UK's withdrawal since the people have voted to leave the European 3.5 years ago. On the economy, we've already spoken to the objective analysis. I don't think I'm going to say anything more on new clause 38. On human rights, I'll cover that in a slightly later clause in more detail. On new clause 20, on mutual recognition, this raises a number of important issues on adequacy and equivalence with the EU in a number of areas for the future relationship. The government fully agrees that in some areas it would be appropriate for the agreement of arrangements for the sort that my right honourable friend mentions. For instance, the political declaration envisaged reciprocity and of adequacy decisions in the area of data protection. But we do not believe, the government does not believe, that adequacy decisions, mutual recognition or equivalence arrangements are always in the best interest of the country, for interest where they rely on alignment with future EU rules. Whilst I do understand the thrust of my right honourable friend's amendment, I don't think it's helpful to constrain the Prime Minister and his negotiating team in prescribing negotiating objectives too precisely. The government will always listen to right honourable members' views, and I'm particularly grateful for him as the stewardship of the department, which is about to come to an end due to the success of his work and the success of many other contributors, including some fantastic civil servants and a truly exceptional Secretary of State in my right honourable member for Cambridge. Moving on, before being nice about my boss, Sir George, always a good idea. New clause 27 deals more with the environment issues. Sadly, the government can't support this rule, and I'll go into a bit more, can't support this clause, and I'll go into a bit more detail. The UK is an advanced and a modern economy with a long history of environmental protections supported by strong legal frameworks, which predates, in some cases, the EU. We will shortly be bringing forward an Environment Bill which will set new ambitious domestic frameworks for environmental governance, including, crucially, establishing the Office for Environmental Protections. This will build on the 25 environmental plan, which we're partway through, admittedly early in the 25-year plan, and provide the assurances that will be upheld. Certainly.
I'm grateful to him for giving way. On the issue of the new Environment Bill and the Office of Environmental Protection, can he guarantee that it really will have sharp teeth, that it will have the same kind of enforcement powers that we've been used to from the European Court of Justice? Because the previous version of the Environment Bill certainly did not have that kind of watchdog. It was much more of a poodle than a really dog with a bark.
Well, there ain't no point in having one of these things if it doesn't have teeth, and it doesn't bark, and it doesn't have a bit of bite. So I think I can commit the government on all of those points, and I thank the Honourable Lady for that intervention. And the government is committed to remaining a world leader in this area once we've left the EU. Leaving the EU gives us the opportunities to put environment front and centre in our policy making. New clause 31 relates to the European Medicines Agency, which I'd now like to talk to. It requires the appropriate authority to take the necessary steps to implement an international trade agreement which enables the UK to fully participate after Brexit Day in that specific authority. This again is one of the things that we need to consider during the implementation period. I don't think it is for this bill. This bill is plain and simple to get Brexit done. It's not a bill to hang on lots of other things, and in these 21 clauses there's many areas of agreement things that we're actually supporting, things that are in the Queen's speech, things that are in the Conservative manifesto, but it doesn't mean they need to be specifically in this bill. Turning now to new clause 32 on erratum, I'd like to thank the honourable member who's not here for the amendment, but it is neither practical nor desirable to maintain the UK's membership whilst leaving, when we leave the EU. There are a number of reasons for that, and given the honourable gentleman's not in the chamber, I'm happy to write to him detailing those, conscious of time. On security, new clause 35, I've already outlined a number of points, so would not disturb the House any further. On new clause 45, I would like to be very, very clear. The government has been consistently clear that when we're negotiating trade deals, the NHS will not be on the table. The price the NHS pays for drugs will not be on the table, and the services the NHS provides will not be on the table. Turning to Horizon, which was an associated point, I can write to the honourable lady with detail. I've seen the value of Horizon. I understand it's not quite as simple as just the money. It's about the participation. I know she's passionate about that. There are similar points in relation to Erasmus and the other agencies, so I will not trouble the House too much on that. Oh, of course.
I thank the member for giving way, the Minister for giving way. Of course, the NHS is devolved in Scotland. Could I make a personal appeal, I'm sure my Scottish National Party colleagues would agree with me, to work as closely as possible with the Scottish Government to make sure that the same laudable thought that it should not be up for sale with the NHS would apply to Scotland as much as the UK?
I agree, and I'm meeting with the Scottish Government tomorrow, and I will make that point. It's my first sentence. I thank the honourable gentleman for that. Conscious of time, and the House has me again on to amend two speeches later. I'm not going to go into more detail on new clause 49, given citizens' rights was covered quite extensively. On observer status of the devolved assemblies in the EU, it would be wrong, given we are, as a country leaving the European Union, to give special status to the devolved assemblies. The devolved assemblies come out with us. And turning finally to new clause 50 on the Charter of Rights, there is no need for a report on this. We will maintain human rights and liberties. They are fundamental to the European Union, and nothing we do in leaving the European Union changes this. For Gary, thank you. Sir George, thank you very much for you and your team for standing in for this bill. I think there has been a change of tone in the House. I'm looking forward to serving this Parliament over the next period. I think it's a better place, and it's a better place for delivering Brexit. It's now over to the House of Lords.
Order, it's very kind of the Minister to say so, but I don't think I can take any personal credit for the change in the tone in the House. The question is that new clause 2 be added to the bill. As many of that opinion say aye? Aye. Of the contrary, no? No! Division! Clear the lobby. Clause 2 be read a second time. If any of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Liz Twist and Jeff Smith. Tellers for the noes, Tom Pursglove and James Morris. Order.
The ayes to the right, 255. The noes to the left, 344.
The ayes to the right, 255. The noes to the left, 344. So the noes have it. I will now call new clause 10 for separate decision. Layla Moran to move formally. The question is that new clause 10 be read a second time. As many of that opinion say aye. Aye. Of the contrary, no. No. I think the division. Clear the lobby. And be read a second time. As many that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Alistair Carmichael and Christine Jardine. Tellers for the noes, Tom Persgloves and James Morris. Order.
The ayes to the right, 254. The noes to the left, 344.
The ayes to the right, 254. The noes to the left, 344. So the noes have it. The noes have it. Unlock. I will now call new clause 29 for separate decision. Layla Moran to move formally. The question is that the new clause be read a second time. Many of that opinion say aye. Aye. Of the contrary, no. Division. Clear the lobby.
That new clause 29 be read a second time. As many of that opinion say aye. Aye. Contrary, no. The tellers for the ayes, Alistair Carmichael and Christine Jardine. Tellers for the noes, Tom Persglove and James Morris. Lock the doors. Order! Order!
The ayes to the right, 250. The noes to the left, 345.
The ayes to the right were 250. The noes were left to the left were 345. So the noes have it. Unlock. Order, order.
Third reading?
Tomorrow.
Tomorrow. We now come to the deferred divisions motion. Minister to move formally.
I beg to move.
As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to the announcement of the election of deputy speakers. Before I announce the results, I would like to thank the Right Honourable Member for North Thanet, the Right Honourable Member for Knowsley and the Honourable Member for South West Devon for serving as temporary deputies. I will now proceed to read the results. Have we got the candidates? Okay. The first one to be elected is Dame Eleanor Lang. Was elected the first ever woman, first woman to be elected chairman of Ways and Means. You're all clapping, whatever we do. Right. I would now like to announce the next position. Dame Rosie Winterton was elected first deputy chairman of Ways and Means. The election of the second deputy chairman is to Mr. Nigel Evans. Can I congratulate those elected and look forward to working with them as the new Speaker's team. This is also, as I said earlier, the first time a woman has been elected to the position of Chairman of Ways and Means, so it's an historic occasion for this House. The result of the count will be made available as soon as possible in the Vote Office and published online. Thanks. Thank you. Point of order.
Thank you, Mr. Speaker. It's just that I want to stand up in the chamber because it's my one opportunity in very many years to do so. May I, on behalf of all the candidates who took part in this election, thank the clerks for the way in which they conducted it and the swift way in which they produced the result. And may I also thank all of the other candidates for their courtesy in the way in which the campaign, however short it might have been, was fought. And may I say to you, Mr. Speaker, that you and I have worked very well together for a great many years, and I'm honoured and delighted to be re-elected to be part of your team. I know that you intend to do a lot to bring this place into the 21st century and to restore faith in our democracy. And I look forward to doing all I can to helping you. Thank you very much.
Right. With leave of the House, we will debate motions number 2 on section 2 brackets A brackets of the European Withdrawal Bill number 2 Act 2019 and number 3 on section 13 bracket 6 brackets A of the European Union Withdrawal Act 2018. Together, I call the Minister James Duddridge to move the first motion. Minister.
Thank you, Mr. Speaker. In a bid to improve my popularity, I'd like to make it very clear I'm going to be very short, and this debate should be short and be on the front benches and a few speeches. We should be able to get over this quickly. I beg to move the motions standing in the name of my right honourable friend, the Secretary of State for exiting the European Union. The Government is required by law to move these motions, which relate to a report and a statement published by the Government on the 8th of November 2019. last October, Parliament failed to approve the revised deal negotiated by the Prime Minister, and this triggered a requirement for the Government to seek an extension to Article 50 period to the 31st of January. This in turn triggered reporting requirements under Section 13 of the European Union Withdrawal Act 2018 and Section 2 of the European Union Withdrawal Act No. 2 Act 2019. The statement outlined how the Government proposes to proceed in light of the House of Commons vote in October 2019. A report for the purposes of Section 2 was also published explaining what progress had been made in the negotiations with the UK's relationship with the EU. Both are available on gov.uk and are in the Vote Office. For the benefit of honourable members who have not read these reports, they make it very clear the Government has no further plans to change the terms of the withdrawal agreement regarding our exit on the 31st of January. Mr. Speaker, the reason is quite simple. We will be leaving the European Union with the Prime Minister's deal at the end of this month.
The question is, that's on the order paper. Paul Blomfield.
Hear, hear, hear.
Thank you, Mr. Speaker. And I'm conscious that with House nights, nothing better than an opportunity to debate our departure from the European Union. And I will make some fairly brief remarks in response. Making the point that we're having this debate today because of the opposition's success in the previous Parliament, working with colleagues from all parties, including the benches opposite, to secure a meaningful vote on the withdrawal agreement and to prevent no-deal Brexit. It's not just, and I'd make the point, it's not just on our side that we've benefited from the provisions in Section 13 of the EU Withdrawal Act and the EU Withdrawal No. 2 Act, but members from across the House who were given the opportunity to question ministers on the various withdrawal agreements and indeed to vote them down 3 times. And those participating in those votes are well represented here, including the Prime Minister who's not. The Withdrawal Agreement Bill, which we've been debating over the last 2 days, repeals both Section 13 of the EU Withdrawal Act and the Ben Act in its entirety. And clearly I don't want to repeat the debate that we've been having or preempt the exciting debate that we can anticipate tomorrow on third reading.
Hear, hear.
But it is disappointing that the Government has refused to accept a single one of the many sensible and constructive amendments that were tabled to that bill. We will clearly not oppose either of the motions today, but I would say that with Parliament's role in ratifying the withdrawal agreement soon to be completed, it's deeply regrettable that the Government has used the Withdrawal Agreement Bill to undermine parliamentary democracy so severely by reducing our role in future overseeing the negotiations on the future relationship. If anybody thinks that the past few years in negotiating the first stages of our departure from the European Union have been difficult, then that's nothing compared with the negotiations yet to come. The decisions over our future relationship with the EU will have consequences for generations, and it isn't the time to lock Parliament out of decision-making and to diminish our role in scrutinising government. Securing Parliament's role in the first phase of negotiations was dragged out of the Government kicking and screaming, both through the Supreme Court and by votes in this place. The right response for a government after an election in which it won a clear majority of seats but failed to win a majority of votes is to move forward with humility and attempt to build consensus. But instead, I'm disappointed that this government is responding by threatening the judiciary and excluding Parliament. We have seen over the last few years that the government will do all it can to avoid its responsibility to Parliament, up to and including proroguing us to avoid obligations in the legislation under consideration today. I hope that members opposite will reflect on whether voting to lock themselves out of any influence over the Brexit process going forward fulfils the ambitions of parliamentary sovereignty for which so many of them have argued over the previous few years.
Patrick Gray. Thank you, Mr. Speaker. I just want to contribute very briefly as well. I think it's quite right that there's a bit of a sombre and reflective mood in the House as we consider these motions, because they are the legacy of the cross-party efforts that went in the last Parliament to ensure and secure as much scrutiny as possible of the government's Brexit proposals. And given that the whole point of Brexit, as we heard in today's debates earlier today, is supposed to be about taking back control and the restoration of parliamentary sovereignty, I think it was absolutely right that those efforts were made. And I think we should pay tribute actually to the members, many of whom are not here anymore, whose legacy is still being felt in what is effectively the Grieve motions as a result of the Grieve Amendment in 2018 and the Ben Act in 2019. I also want to pay tribute to my former colleague Stephen Gethins, who was part of so much of that cross-party cooperation. But they did, in establishing those amendments and the legislation, they pushed the boundaries and they set new precedents, and they are going to be particularly important in the post-Brexit world in holding this government and executive to account for the power grab that it is now perpetrating with the bill. So I think it is right that as we go through the remaining stages of the Brexit legislative process, that the mood is one of reflection and consideration and not one of triumphalism and bombast that we hear from the Maastricht rebels and the ERG on the other side of the House. They might want Big Ben to chime at 11 p.m. On the 31st of January. I'm not sure if they'll be successful with that request, and perhaps they shouldn't be, because we know the trouble that Brexit is going to bring. So they might want to reflect, as they continue with their campaign, on the old admonishment of "do not ask for whom the bell tolls. It tolls for thee."
No man is an island.
The question is as on the order paper. As many of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. Motion number 3, section 13 bracket 6 bracket A of the European Union Withdrawal Act 2018. Minister to move. The question is as on the order paper. As many of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 4 on section 3 brackets 2 of the Northern Ireland Executive Formation etc. Act 2019. Minister to move.
Thank you, Mr. Speaker. I'm taking this debate on behalf of the Secretary of State for Northern Ireland, who is currently in Belfast in talks with the Northern Ireland parties, working towards getting Stormont back up and running. On the 18th of December, the Northern Ireland Office published on gov.uk a report setting out the latest position on progress on executive formation, transparency of political donations, higher education and a Londonderry University, presumption of non-prosecution, troubles prosecution guidance and the abortion law review. The Northern Ireland Office then laid copies of that report in both houses now that Parliament has returned. Copies of all the previous reports are available on gov.uk. It was the 7th and final report published on these issues in line with our obligations under the Northern Ireland Executive Formation Act 2019. Mr. Speaker, it is the Government's absolute priority to get Stormont back up and running before the 13th of January deadline. Colleagues across this House understand the issues at stake here. Failure to restore the institutions will raise difficult and urgent decisions about the future governance of Northern Ireland. The Secretary of State remains in Belfast today to facilitate talks. All 5 party leaders remain positively engaged in the process, and our assessment is that it remains possible but challenging for the parties to secure a political agreement before the deadline. We all recognise how closely that deadline is now looming. If 13th of January passes without agreement, the Secretary of State will fall under a legal obligation to call an assembly election. And I'm hopeful that, as we've heard in previous debates of this nature, members across the House and from all parties will join me in urging the parties to come to an accommodation so that a restored Assembly and Executive can get on with resolving the real challenges that continue to frustrate the daily lives of the people of Northern Ireland. Mr. Speaker, turning to the abortion report, the Government is working towards the laying of regulations for a new legal framework for the provision of abortion services in Northern Ireland as required by the Act. This new framework will be enforced by the 31st of March 2020. Women and girls who are seeking to access services in the meantime can do so in England free of charge, with all the costs of the procedure, including travel and where needed accommodation, being paid for by the Government. Arrangements can be made through contacting the Central Booking Service, and we have published the contact telephone number and the services provided on gov.uk. The public consultation on the legal framework for provision of services closed on the 16th of December. During the consultation period, officials continued engaging with health professionals, individuals who have been affected by the law, civil society organisations and women's groups, including Doctors for Choice, Alliance for Choice, Here NI and Women's Resource and Development Agency, on the proposals set out in the consultation document. We are currently analysing these responses, having received good levels of engagement from many different viewpoints. As made clear in earlier debates and indeed in the foreword for consultation, we were seeking views on the question of how the framework can best be delivered in Northern Ireland, not on whether this reform should be happening. The Government's response to the consultation will be republished in due course. We are happy to continue discussions with interested parties as the regulations are taken forward in line with what is required under Section 9 of the Act, that the recommendations of the 2018 UN CEDAW report are implemented in respect of Northern Ireland by the 31st of March 2020. The Government will continue to abide by its legal obligations. On the presumption of non-prosecution and troubles prosecution guidance, Mr Speaker, reforming the legacy system in Northern Ireland remains a top priority for the UK Government. We will always owe a vast debt of gratitude to the heroism and bravery of the soldiers and police officers who upheld the rule of law and were themselves accountable to it. The Government is strongly opposed to our service personnel and veterans being subject to the threat of vexatious litigation in the form of repeated investigations and potential prosecution arising from historical military operations many years after the events in question. The Government recognises the concerns that have been expressed about the way the current system is operating in Northern Ireland and is committed to seeking the prompt implementation of the Stormont House Agreement proposals on legacy in order to provide both reconciliation for victims and greater certainty for military veterans. Any legislation which improves the legacy system in Northern Ireland will need to be agreed by the UK Parliament and have the support of a restored Northern Ireland Executive. The Secretary of State for Northern Ireland is working closely with ministerial colleagues and the Northern Ireland parties and the Irish Government to this end. The issue of transparency of donations to Northern Ireland parties is one that we take very seriously. Northern Ireland parties are now subject to the same reporting requirements as our other parties across the UK. That is a significant step forward, but the question of retrospectively opening up records from 2014 remains genuinely difficult. At a time when threats to elected representatives are all too common, we must be very careful that anything we do should not lead to intimidation against members of the public who donated to parties. We will consult with the Northern Ireland parties in due course about any future change to the legislation, but I hope you will understand, and I hope the House will understand, that for now our focus must remain on securing agreement to restore devolved government for the people of Northern Ireland. Mr Speaker, on higher education and a Londonderry University, there has been no progress since the last report, which was laid on the subject on the 4th of December. No business case has been submitted, and therefore we are not able to assess proposals. The Government has been clear on its commitment to turbocharging the economy and levelling up all regions across the UK, and the Derry and Strabane City deal and the Inclusive Future Fund, which formed a £105 million economic package for the North West, is further evidence of that commitment. We are aware of the support that exists for the extension of higher education provision in the North West, and this is another example of a project in Northern Ireland facing barriers due to the lack of devolved government. Restoring the executive would remove blockages and, with executive approval, allow funding to be unlocked for expanding higher education provision in the North West. Turning to payments to victims of troubles-related incidents, in October the Government launched a public consultation on a scheme for regular payments to or in respect of individuals living with serious disablement caused by troubles-related incidents. The proposed scheme is intended to provide acknowledgement to those injured in the troubles-related incidents through no fault of their own. The consultation closed on 26th of November. Responses are being carefully considered and will inform final decisions regarding the scheme. The consultation proposed not to make payments to individuals with a criminal conviction directly related to the incident in which they sustained the injury. We will make regulations in this area by the end of January, as is specified in the Northern Ireland Executive Formation Act 2019. The scheme will then be open for applications no later than the end of May 2020. Victims injured through no fault of their own deserve this form of acknowledgement and measure of additional financial support, which is a core element of the Stormont House Agreement's proposals to help address the legacy of the Troubles. It remains vital that we make progress on this and related matters. Mr Speaker, as you and colleagues across the House will know, the Government is also under a duty to make regulations to provide for same-sex marriage and opposite-sex civil partnerships in Northern Ireland by the 13th of January 2020. On the 23rd of December 2019, the Northern Ireland Office laid regulations before Parliament that mean from next week, on the 13th of January, same-sex civil marriage and opposite-sex civil partnerships will be lawful in Northern Ireland. Couples will therefore be able to register their intent to enter into such a relationship with a minimum 28-day notice period required, so as previously previously stated, we expect ceremonies will be able to take place during the week of Valentine's Day. There are still two key issues on which we will be seeking the views of the people of Northern Ireland before we legislate further. That is on same-sex religious marriage, together with the appropriate protections, and the right to convert from a civil partnership to a marriage and vice versa. We want to consult on both matters in order to ensure that the legislation takes proper account of the specific circumstances in Northern Ireland and provide adequate religious protections. The consultation will be seeking views from religious bodies and individuals on how religious same-sex marriage will be provided for in Northern Ireland and how protections can best be achieved. We also want to get the right approach for conversion entitlements for Northern Ireland, given the different approaches taken across the rest of the UK. The Government hopes to be able to launch a short consultation on these two issues from mid-January, and we will bring forward regulations as soon as we are able to in 2020. Mr Speaker, I am very pleased to have the opportunity to discuss these important matters, but more importantly to hear from Northern Ireland members on these matters before this House and recognise the sincere and deeply held views surrounding some of the topics discussed. In conclusion, I want to reiterate the Government's undiminished commitment to see Stormont back up and running again. Northern Ireland needs its own locally elected representatives making decisions on local issues and making Northern Ireland's voice heard across the UK.
The question is, that's on the order paper. Tony Lloyd.
Thank you, Mr Speaker. Can I congratulate the Minister? I think he made a 20-minute speech in just over 8 minutes. And he's been on his feet all day. Nevertheless, this actually is an important report, and the Minister has raised before the House a number of important issues. So, if I may, I'd like to begin sequentially pretty much where he began. I have some questions that I hope the Minister is able to at least help the House. Under the legislation passed by the House in terms of providing safe and legal abortion for women in Northern Ireland, there is now an obligation on the UK government to ensure that by the 31st of March there is provision in Northern Ireland for that service. And as the Minister has told the House, the consultation on this is now concluded. I need to ask the Minister, though, will he guarantee, if it is this House that has to discharge the legislative duty, that consultation should be brought to the House in enough time for us to examine the results of the consultation before the legislation or the necessary steps are brought before this House? But also recognising, I hope we recognise that by that time there may well be back in operation the Stormont Assembly. It would be futile if we were to find that the Assembly itself wished to legislate in a way that was contrary to the manner in which the UK government established the process for safe and legal abortion. And in that context, clearly, what I would ask is that there is now, if we do see Stormont back up and running, there's the closest possible working relationship between the Westminster government and the newly formed executive to ensure that there is a smooth transition on this question so that we can deliver to the women of Northern Ireland exactly what the House dictated that there should be from the 1st of April, safe and legal abortion in Northern Ireland. On the second issue that the Minister raised, in terms of the potential prosecution of those who perpetrated violence during the cause of the Troubles, I would quote from the report that appears before the House tonight, where quite rightly the government says the UK government will continue to seek better ways of dealing with legacy issues that provide better outcomes for victims and survivors. And I'm grateful to the Minister for what he said about the potential for payment to victims of the Troubles. That's right and proper. Many of those who suffered are no longer with us, some for obvious reasons, but some simply because of the passage of time. And of course, there is no compensation that can avail for those. But nevertheless, there are a group of people who are dependent on seeing now some progress on this area. So the Minister's words will be welcome, but we do need to see real progress on that. But can I also make the point that, of course, outcomes for victims and survivors does include, where appropriate, the prosecution of the perpetrators of violence against those victims or against possibly the families of those victims. And that's a legitimate demand. And whilst the Minister uses the word rightly, that we want to avoid vexatious prosecutions, let us be absolutely clear as a House that we are not turning our back on the rule of law, that those who are guilty of the most heinous crimes, murder, manslaughter, nevertheless must still face the full force of the law. There can be no statute of limitations that provides an artificial form of protection, because this simply, I think, would be unacceptable both to we as a House of Commons, we as a public, but also our obligations under international law. Mr Speaker, I then would like to move on very briefly to raise with the Minister the question of something allied to the payment for victims of the Troubles, was in fact victims of institutional abuse. Now, I know this is something possibly the Minister can't give a fulsome answer to tonight, but it would be very helpful if we could begin to see and make sure that we can see what the process of payments for those victims of abuse begins to look like. We know quite rightly, we as an opposition were very happy to work with the government just before Christmas, and generally speaking very much against emergency legislation done over rapidly. It can lead to problems and issues later on. Nevertheless, we all quite rightly conspired together to insist that that legislation was put on the statute book before the House was dissolved for the general election. Obviously, what that does require now to know, though, is how that process is working out, where we're up to in terms of interim payments for victims of institutional abuse, and where we're up to in terms of the creation of a redress board that can begin the process of making sure that we now have a well-worked formula for those who suffered, and let's be very clear about this, suffered sometimes because of I think it's not unfair to say the incompetence of the statutory authorities, sometimes rather sadly at the hands of those who were there to offer care. But one way or the other, our society owes support to what is now an ageing population, and again a population that leaves us almost literally day by day, where the numbers are decreasing, and I hope the Minister can at least give us some satisfaction in that area. Mr Speaker, the next item I want to raise very briefly is something that the Minister may well not be totally apprised of. It's the question of business rates, which has emerged, I think, almost literally over these recent hours. The business rate revaluation, as it's been announced, has seemingly given quite severe increases in business rate payments, particularly to certain parts of retail, to small shops, and to the pub and hotel trade. Now, clearly, there will ultimately be, I think, obligation on a reformed Assembly to make sure that they deal with this issue. But I would like to, at least for the Minister, to take on board the fact that this can have a detrimental impact. And if we look at what most of us in the House would look to in our own constituencies, we know that the small shop, we know that the pub, the hotel, can be a central part of keeping the town centre alive, can be a central part of keeping our communities alive. And it's important in my constituency, and it's obviously important in Northern Ireland, that we have some sense of proportion in any change in the business rates basis. I finally would like to turn... Yes, of course.
I'm very grateful for the Shadow Secretary of State for Northern Ireland for giving way. One issue that the Minister did not mention in relation to bringing information to the House was those born in Northern Ireland who identify as Irish and as Irish citizens, and therefore European Union citizens, exemplified by the De Sousa case. And does he not agree that it's now time that the report promised by the former Prime Minister, promised on the floor of this House, to which many of us asked for, is brought and presented and put in the library of the House of Commons?
The honourable member is absolutely right in not his plea, his demand. The De Sousa case shames us, I think, as a society. We ought to resolve the issue, yes, for that particular couple. I met them, of course I have, but actually more generally, this issue about the status of those who consider themselves to be Irish does matter. It's part of the Good Friday, the Belfast Agreement, and it's something that this House is committed to. Every party in this House is committed to, and we ought to make sure that our obligations are translated into something of practical value to the De Sousa family, and so I'm grateful for the intervention. Mr. Speaker, I would though like to turn now to the question of the situation of those working in the health service pay in Northern Ireland, because this now has reached crisis proportions. This has reached crisis proportions when I can say to the House that in Northern Ireland, for example, a hospital porter, a hospital cleaner, would be paid a wage of some £16,943. And this compares with the comparator in England and Wales on some £700 more, 17,650. So I've got to say to Scottish members, actually better again. In Scotland, I can go through the situation of healthcare assistants and administrative workers, but for nurses and paramedics the same. And let me use the reference point of senior nurses. A senior nurse in Scotland and England and Wales would be paid £30,401 a year. In Northern Ireland, significantly less, £27,772. Now, this cannot be acceptable, and I know of nobody who accepts that there is justification for this position. Not any of the parties in the Northern Ireland Assembly accept this position. We as an opposition don't accept that position. This has to be resolved. Now, what I must say to the Minister is this. I very strongly hope that the words that he began with, that the Secretary of State is in Belfast now trying to make sure that the all-party talks do come to a fruition, that we see the Assembly restored, will in fact come to the conclusion that we all want to see that's right and proper, in which case the Minister can say this issue can be translated over to the Assembly. However, I must give the Minister a real warning on this, that if that Assembly isn't back up and running, and isn't back up and running in short time, if we do face, for example, the possibility of prolonged delay through an election, it will be incumbent upon the Westminster Government to look at this situation. Those nurses, those administrative workers, those hospital porters and cleaners should not have to wait possibly for an indefinite amount of time in the future, particularly when almost uniquely nurses have gone on strike because of the length of the time that they've seen this disparity in income and the unfairness of the situation that they face. And I will say to the Minister, because it's always convenient, I've got to say, for ministers in the Northern Ireland office to say, well, this really ought to be a devolved issue. This is not necessarily a devolved issue. Clearly, if the Assembly is back up and running, there is a strong argument it should be resolved by the Assembly, as long as the resource base is there for the Assembly to make those pay increases. If the Assembly is not up and running, in actual fact there is legal basis, and I'm happy to go through this with the Minister and the Secretary of State in due course, as to why actually the legal base does exist for this to be delivered by Whitehall, by the Westminster Government. And it's important that the signal is given now to people in the health service in Northern Ireland that their long struggle for fairness is one that will shortly come to a conclusion. Now, Mr. Speaker, I will conclude on this remark. My honourable friend, the Shadow Secretary of State for Wales, became a grandmother this morning. Her grandchild, Jessie Carney, is an Irish father and has happened to a Welsh mother, but nevertheless a mother from Great Britain. I'd like to believe that the generations of the Jessie Carneys will grow up in a world very different to the one that we have at the moment, one where we have a robust Stormont Assembly, one where we have a robust system of governance in Northern Ireland, where we have a system that not only is robust there, one that allows us to put the history that we're talking about tonight, whether it's the history of violence or whether it's the legacy of abuse, so far in the past, that a generation can grow up in hope in a transformed society. That's what this House has got to be about. That's why we can't have excuses, I've got to say, from the Treasury bench, or actually excuses from the parties in Stormont. We now have got to see the Secretary of State's genuine efforts, and I applaud his efforts, brought to a conclusion so that Northern Ireland can begin to move forward again with a properly working Assembly, and an Assembly that can begin to deliver to not simply the hospital workers, but to the people of Northern Ireland the transformation that Northern Ireland now needs.
Mark Carp. Thank you very much, Mr. Speaker. I rise to speak in this debate really for several reasons. I applaud the fact that the Minister is taking this debate and the fact that the Secretary of State is not here. That's not something you usually say, but given the task the Secretary of State is engaged with and his focus on that, I think that is welcome. I fear, though, I share the Minister's hope that the talks conclude with a positive outcome, and prior to next Monday's deadline, we can see an agreement to restore the executive in Northern Ireland, because it is, I think, unquestionably the case that devolved government is the right long-term solution for Northern Ireland. But I do say to the Minister, and I listened carefully to what he said about the options available to the Secretary of State, I do think that the government and this House and all of the parties in Northern Ireland, more of whom are now represented in this House than was the case prior to December's election, we all owe collectively a duty to the people of Northern Ireland to make sure that that part of the United Kingdom is properly governed. And I fear, and I say this partly to the Minister but also to those parties in Northern Ireland, if by next Monday we don't see an ability to restore the Stormont executive, I don't think, for reasons I will set out in a moment, that the option of either kicking the can down the road by extending the deadline or indeed having another Assembly election, I'm afraid is going to be up to the task. And I fear we will be confronting a binary choice of either getting the Assembly up and running, but if not, I think we are going to have to some extent, have executive decisions taken by ministers accountable to this House. And let me just set out one area where I think that is necessary, and I pick up and follow on actually from what the Shadow Secretary of State said. I agree with what he said about the important health workforce issues in Northern Ireland, and I think the fact that health workers in Northern Ireland, nurses in Northern Ireland are on strike is incredibly regrettable. But worse, I think, is the performance of the health service. And I think if I look at two particular factors, one is the length of time people are waiting for treatment. In England, in the last set of statistics, just over 1,000 people, 1,233 people were waiting more than a year for treatment, for seeing a consultant. In Northern Ireland, and I don't think I need to elaborate to many members of this House the difference in population sizes, the number of people waiting, I understand, for more than a year to see a consultant is 103,000 people. That's a third, over a third, of all of the people waiting for health treatment. And the cancer waiting times mean that a fifth of those people who receive a cancer diagnosis are receiving the cancer diagnosis in the emergency department of a hospital. And I don't know what the precise statistics are, but it seems very likely that thousands of people are therefore dying unnecessarily by not receiving timely health treatment. So I don't think it is an exaggeration to say that the lack of devolved government in Northern Ireland, where ministers accountable to the people of Northern Ireland are able to take the necessary decisions to reform the health service, to implement pay awards, to recruit the necessary staff, and to make sure the health service is running efficiently, is directly leading to the deaths, the unnecessary deaths of people in Northern Ireland. And I don't think if we're unable to see a Stormont executive and Assembly re-established next week, I don't think in good conscience we can allow that situation to continue if it means the early deaths of citizens of our own country, part of our own country. So I think that when ministers and the government are going to be faced with a very difficult decision, that if we don't see a restored executive and assembly, I don't think it's going to be a realistic option, unless we are literally on the cusp of an agreement, to just kick the can down the road again, extend the deadline, or have elections. And I've looked carefully at the result of the general election in Northern Ireland and looked at how that compares to the result of the last Assembly election. And it doesn't seem to me, looking at the difference of performance of the relevant political parties, that there's anything about an Assembly election taking place in the present political circumstances that's going to lead to an outcome that's going to enable the formation of an executive after an Assembly election that isn't capable of taking place next week. Of course, I'll give way.
I thank the honourable member for giving way. Just when he's elaborating on that point, would he agree with me that however much people might relish an election, it is difficult to see in the current context, if an election were to be held, that the exposition of the problems that we've been faced with over the past 3 years would change to any degree, either before, during or after an Assembly election?
I agree with the honourable gentleman, and I said I've looked at the balance of opinion of the political parties, and it seems to me the exact number of seats that they might have would differ, but I think the broad order of ranking wouldn't change. And it also seems to me there's a danger that the issues which I won't elaborate on, that we know are the contentious ones that are preventing the coming together of the political parties to form an executive and to get the Assembly up and running, it seems to me the danger of an election is that that would cause those issues, people to dig in further and to be less capable of the necessary compromises, because parties will have staked out those positions in an election campaign. So all I would say both to the Minister and to my valued colleagues from Northern Ireland is I fear that we're approaching a decision point where if the parties in Northern Ireland are unable to re-establish an executive and an assembly, I fear the government, at least in the short term, is going to have to come to this House with a proposition that some level of direct rule by Westminster ministers is going to be necessary. And I completely agree, that is not the right long-term solution for Northern Ireland. But for the reasons I set out, if for no other reason than the performance of the health service, which I think is close to falling over, I don't think in good conscience we can allow that situation to continue. And the Shadow Secretary of State set out some other issues as well. So that is my first point. My second and final point was really to ask the Minister if he was able to furnish the House with any further details about progress on the legacy prosecution issues. I noticed in the report that officials were continuing during the general election campaign to work through options, and I recognise what he can say is probably limited, I think, from what he said before, because obviously we would only want to make progress with the agreement of a re-established executive and assembly, and therefore I accept that he won't be able to set out details. What I was hoping he could set out was the progress that had been made, at least in exploring the options, and some hint of a timetable that if we were able to establish devolved government again, how quickly the government would be able to make progress on bringing forward an ability to resolve those legacy issues around prosecutions. Because clearly, for those individuals who are directly affected, whether in live cases or in worry about the future, some understanding of how quickly those issues may be brought to a conclusion would be welcome. So I think those are the two issues really that I wanted to bring in front of the Minister and the House, and also just to set them out in front of colleagues from Northern Ireland, because I think we are approaching a very grave decision point where I fear we may have to take some decisions with some very significant consequences for the future.
Kirsten Oswald.
Thank you, Mr. Speaker. People all over Northern Ireland and people further afield as well are going to be watching this closely and with great hopes for progress. It seems that there is the potential for progress, but time is running very short. And there's no doubt that people in Northern Ireland, as we've heard, have paid the cost of an absence of devolved government. And this is now the best and perhaps the final opportunity to restore these institutions. So it is critical that every effort is made to secure a deal. And that deal won't come without significant effort and without compromise from all of those involved. The indication that a joint paper will be published by the two governments later in the week, the movements of the Secretary of State, are welcome, because we need to be clear the consequences of not securing a deal before the 13th of January could be much more profound than simply another Stormont election. We know the Secretary of State previously suggested that in the continued absence of a government at Stormont, and with Brexit requiring significant executive direction, a return to some form of direct rule will be required. We've heard from the member opposite who has expressed similar thoughts. And any return of direct rule would undermine previous political and peace agreements. I think it would be most regrettable. The Scottish Government is absolutely committed to all of the institutions of the Good Friday Agreement and to making sure that their stability and the stability of the peace process is not undermined amidst the Brexit chaos. I'm sure that the Minister knows that both the EU and the US Congress have said that there will not be a free trade agreement with the UK if Brexit in any way undermines the integrity of the peace process. And just like in Scotland, the recent general election has again reinforced the Northern Ireland electorate's choice to back parties who wish to retain EU membership. And it's wrong and undemocratic that Brexit's being imposed on Scotland and on Northern Ireland. And it is absolutely crucial that the UK Government respects the wishes of the people in Northern Ireland and the pillars of the peace process. They must find ways of avoiding interfering with the delicate balance of these relationships which have been so hard won. Mr. Speaker, as part of a deal to restore Stormont, it has been widely speculated that Northern Ireland businesses would receive Brexit mitigation. And indeed, Northern Ireland business organisations have said that they will seek over £100 million to mitigate the effects on the economy. We do not begrudge that financial help. But if there is to be a Brexit mitigation package for Northern Ireland, then that is an admission of its cost to business and communities, so such a fund must also be replicated in Scotland. Indeed, as part of the Prime Minister's deal, Northern Ireland firms will already have access to the European single market, which is denied to Scottish businesses, and that risks placing them at a major competitive disadvantage. And if we reflect back briefly to the last Parliament, the UK Government failed to make sure that the funds handed to the DUP were subject to the Barnett formula, which again means that Scotland's budget was denied over £3 billion. Now, I know, Mr. Speaker, that this debate will be of interest to viewers in Northern Ireland in particular, and as has been discussed, some of these may well be nurses who perhaps would usually be on a shift, but today they are on strike, and that strike of nurses today in Northern Ireland is absolutely testament to the need for decisions to be made locally. And people in other places might be unaware of that strike and unaware of the unprecedented nature of the strike in protest against pay and staffing levels that the nurses say are unsafe. There's no doubt at all that the lack of government and political direction is deepening the crisis in Northern Ireland's public services and in their capacity to deliver for people. To give just two examples, the latest hospital waiting time figures show nearly 300,000 people in Northern Ireland are waiting for a first appointment with a consultant. That represents a sixth of the whole population. On average, there is a 4-year wait for knee and hip operations. These things are incredibly serious, and only a functioning and devolved government is capable of tackling that. It can't be left to a dysfunctional and disinterested UK Government to do so. So, Mr. Speaker, that prospect in itself must give renewed impetus to all the parties involved in these talks to come to a compromise, to do everything they can to make sure that that happens, so that everyone in Northern Ireland can be rewarded through the return of their own government. And previous talks have overcome divisions much more significant than the issues currently blocking progress. So we know that this can be done, and, Mr. Speaker, it really must.
Fiona Bruce.
Thank you, Mr. Speaker. Mr. Speaker, pages 9 and 10 of the report we are considering today address the Northern Ireland Office's consultation on new abortion regulations for Northern Ireland. In addressing this subject, it's important to remember that abortion is a devolved policy competence, indeed in Northern Ireland for almost 100 years. And in 2016, the democratically elected Northern Ireland Assembly voted by a straightforward cross-community majority not to change its abortion law in any way. In this context, the government was absolutely right, as the former Prime Minister, the Right Honourable Theresa May, and the former Secretary of State for Northern Ireland stated on a number of occasions in this place when abortion in Northern Ireland was raised that this is a devolved matter and something for restored Northern Ireland Assembly to consider. This, however, was, sadly in my view, as I stated at the time, ignored by the 2017-19 Parliament, which went ahead and passed the provision which government is now required to introduce a new legal framework for abortion law for Northern Ireland by 31st of March this year. And that is through Section 9 of the Northern Ireland Executive Formation Act 2019. And to that end, government very properly launched a consultation in November. Now, I have to say, having looked at that consultation and the questions that it asked, I was deeply concerned by the width, by the breadth of the content of that consultation, much wider in my view than Section 9 strictly requires, raising concerns, certainly in my mind, about possible changes to abortion law in Northern Ireland going much further than Section 9 anticipated. Can I urge ministers not to take this course of action when the final regulations are published? And I'll go into some detail, if I may. By way of an example, the consultation made references to the conscience of clinicians not to be involved in abortion procedures, something which for over 50 years has been respected, certainly here. And I know that there are a number of clinicians in Northern Ireland who are deeply concerned that respect of their right to conscientiously object to engagement in the abortion treatment procedures may not be given the same respect that it has here. And two, there were references in the consultation questionnaires to exclusion zones, a subject of a consultation here not long ago, which the then Home Secretary decided, following consideration of that consultation, to take no action on. What Section 9, subsection 4 says is that the Secretary of State, by regulation, must make whatever changes to the law of Northern Ireland as appears to him to be, and I quote, necessary or appropriate for the purposes of implementing paragraphs 85 and 86 of the CEDAW report. Now, the CEDAW report, and I won't go into the debate that we've had on more than one occasion in this place about the authority of that report, but the CEDAW report required abortion to be legalised on 3 grounds. That Northern Ireland law should be amended to provide abortion on the following in the following 3 expanded grounds in at least these 3 circumstances: rape and incest, severe fetal impairment, including fatal fetal abnormality, and threat to the pregnant woman's physical or mental health. However, having read the consultation and, as I say, the very wide questions which have been raised within it, I am deeply concerned that the abortion framework which may be proposed by the Northern Ireland Office may go far beyond these 3 circumstances. For example, it may allow for access to abortion on request for any reason up to 12 weeks gestation, and then up to 24 weeks on the basis of the standard in the rest of Great Britain in the Abortion Act 1967, Section 11A, and I'll just read that because it is wider than the CEDAW report proposes. That the pregnancy has not exceeded its 24th week and that the continuance of the pregnancy would involve risk greater than if the pregnancy were terminated of injury to the physical or mental health of the pregnant woman or any existing children of her family. Now, and I speak as someone who's been chair of the all-party parliamentary pro-life group for a number of years. I realise at the moment that we're in a situation where all party groups have got to be reinstated. But I do know from a number of years engaging on this subject that this standard has effectively led to abortion on request. I am not aware of a single case in the last 10 years where a woman who has requested an abortion in England and Wales has been denied one for failing to reach this particular standard. The CEDAW report doesn't require this standard to be introduced in Northern Ireland, nor, as I say, does it make reference to the conscience clause or exclusion zones. Can I urge the Minister to consider that it is possible for the Northern Ireland Office to adopt a much more restrictive standard than the one proposed in the consultation document, whilst at the same time fulfilling the requirements of Section 9. If the Government is to act consistently with its many times stated commitment to respect devolution, I would have thought that it would make sense for it to introduce a new regulatory framework that departs from previous Northern Ireland abortion regulations only to the degree that the 2017-19 Parliament insisted on, but not further. Now, of course, I recognise that the use of the words "at least" in the CEDAW report don't prevent the Government from going further, but I do suggest to the Minister that in the Northern Ireland Executive Formation Act, the words necessary or appropriate do so, and I would urge him to consider that, as well as obviously the spirit of devolution and the fact that when that act was voted on just a few months ago, every single member of the 2017-19 Parliament who represented a Northern Ireland constituency in Westminster voted against it. That law change has been imposed on Northern Ireland by a coalition of MPs representing seats in England, Scotland and Wales. I think that is inappropriate and wrong, and I said so at the time. Indeed, I said that I felt that the whole clause was out of scope, but I appreciate that you were not in the chair at the time, Mr. Speaker. In closing, can I ask one or two specific questions of the Minister? The Government has reported that the consultation document, and the Minister did make mention of this in his opening remarks, has been produced after discussion with a range of stakeholders. Now, yesterday, in the other place, Lord Duncan of Springfield said that discussions with interested parties will continue as the regulations are taken forward. I'd be very grateful if the Minister could perhaps write to me to let me know who were the stakeholders involved prior to publication of the consultation document, if there were others than those he has mentioned in his opening remarks, and also who are the interested parties who will be in discussions with the Government on the regulations going forward. Yesterday too, yes.
I thank the Honourable Lady for giving way on that point, and I think she's making a very good speech. The other group of individuals, and I've been chair of the Disability All-Party Parliamentary Group for the last 2 parliamentary terms, who have had members in touch with me, or the Don't Screen Us Out community, who are particularly concerned regarding the scope of these regulations and the impact upon families with Down syndrome, children, and if the Minister could also perhaps comment on whether or not there's been consultation with that group going forward in relation to the Honourable Lady's speech and questioning. I think that would be very helpful, and I'm sure that's something that she might also feel would be beneficial.
I thank the Honourable Lady for making that point. It's a really important one. And in fact, because I am so concerned about a number of issues relating to these proposals, and I appreciate that the Minister may not be able to respond to our specific points today, I wonder whether perhaps he would be willing to meet with me, the Honourable Lady and other concerned colleagues about the potential extent of these changes, and that too he will reflect on the appropriateness of bringing forward proposals that don't undermine devolution any more than Section 9 absolutely requires. If I can just mention a specific point which I was going to before the Honourable Lady.
Just to intervene, given that I may have very limited time to respond at the end of this debate, I just want to say I'm very happy to meet with the 2 Honourable Ladies to discuss these matters further, and I won't be able to respond in detail in today's debate.
Yes, thank you. One final point, if I may, Mr. Speaker. Lord Duncan yesterday in the other place said There has been no registered growth in illegal or backstreet abortions in Northern Ireland since the current law was repealed in October. And I wonder whether the Minister could also confirm how the government knows this and that doctors are not carrying out abortions, since there is no requirement for them to notify the government or the Northern Ireland Department of what they might or might not be doing at the present time. Thank you.
We now come to a maiden speech. Carla Lockhart.
Thank you, Mr. Speaker, and can I thank the Minister for his update. I count it an honour and a privilege to stand in this place today, the mother of all parliaments, to make my maiden speech as the first ever female MP to represent the good people of the Upper Bann constituency. I want to begin by thanking all those constituents who voted for me on the 12th of December. They have placed their trust in me, and I want to say thank you to them. I will be a champion for them, and I will not let them down. I promise to be a strong and articulate voice for all within my constituency. I'm an unapologetic unionist, but I commit to working hard and delivering for all the people in Upper Bann. I want to pay tribute to my predecessor, Mr. David Simpson. David was a strong advocate for Upper Bann and indeed Northern Ireland. He served with distinction in this House for over 14 years. I wish David and his family well in his retirement from this place. I started my political career at the age of 21 as a local councillor representing Lurgan and progressed to the Northern Ireland Assembly in 2016. My passion for politics and the union started when I was much younger. I had the privilege of growing up right in the very heart of Ulster, in a working class family, and I'm proud of the roots and the grounding that I have. Growing up near the border of the Republic of Ireland and knowing many families who had loved ones murdered, I was always very aware of the troubles in Northern Ireland and why we had such a love for the Union and our British way of life. My early influences, Mr. Speaker, were two men who served in this House with honour and integrity over many years: the late Lord Bandside and the Right Honourable Peter Robinson, former MP for Belfast East, someone who has been a constant source of encouragement to me. I have a long way to go before I can even get close to the level of impact that they made in this House. Both defended the Union and stood up for Northern Ireland with every fibre of their body. And in that same vein, I too will do just that. It is with regret that I do not sit on these benches with the former DUP member for Belfast South and my party's deputy leader, the former member for Belfast North, the Right Honourable Nigel Dodds, an extremely capable orator, someone who contributed greatly to this House. And it's unfortunate that North Belfast has now no representation on these benches. Mr. Speaker, it is no secret that Northern Ireland has had its difficulties in the past, but I am proud of our wee country. It is the best place on earth, with Upper Bann being at the very heart. Lurgan, Portadown, Banbridge, Craigavon and the surrounding villages have their own unique offering, be it tourism, commerce and hospitality. The people are what make it a special place, and if any of you have not visited my constituency, you're more than welcome to come and see that it is a great place to live, work and do business. I've always longed to make a difference in society, make it a brighter, better place for future generations. Northern Ireland suffered greatly at the hands of terrorism, and we do not want to return back to those days. We want a peaceful, prosperous society and one that is moving forward. We have moved on from those dark days in Northern Ireland. We want to see investment, improved healthcare provision, a better education system and improved infrastructure. To that end, I will endeavour to use this position to achieve just that. I want to see changes to our special educational needs provision, and I want to tackle the escalating mental health crisis that exists within our society. Our suicide figures are still amongst the highest within the United Kingdom. This needs tackled urgently, and I, along with colleagues, will work with the Secretary of State. I now move to the motion at hand, and particularly the report concerning abortion. I feel it is imperative that I speak on this to attempt again to highlight the anger, disappointment and frustration concerning the change in abortion laws that have been foisted upon the people of Northern Ireland. These changes came in the most roughshod way, with complete contempt for the devolved administration or the views of the people of Northern Ireland. So I want today to make the point to this House on behalf of the many thousands of people across Northern Ireland who take a pro-life stance that we want to repeal Section 9 with immediate effect and allow for the Northern Ireland Assembly to debate, discuss and evidence gather on this emotive issue. The Secretary of State has not intervened to assist in our crumbling healthcare system, or to fairly reward our healthcare workers, or to avert the mental health crisis we are facing. He hasn't done that because, in his own words, he said these are devolved issues. Abortion was and should be a devolved matter, yet this House has imposed on Northern Ireland the most extreme measures of abortion anywhere across Europe. Northern Ireland has been a country that has always supported life-affirming laws. Back in 1967, our politicians said no to the 67 Abortion Act, and according to research conducted by Both Lives Matters, 100,000 people are alive today. England and Wales back then did support the Act, and as a result, over 8 million babies have been aborted. 3 every minute, 23 every hour, and 561 every day. And that's only a small percentage of them being aborted on the grounds of sexual crime or fetal abnormality. Great credence has been given to the CEDAW report. The Honourable Member mentioned the 3 instances. However, we believe the abortion framework, which looks likely to be proposed by the Northern Ireland Office, will go far beyond allowing abortion on these grounds. It is my understanding that no consultation will take place on the legislative text of the regulations. With regards to abortion, it is well known the detail of the text is crucial. The ask in that is that we, at least as parliamentarians, are consulted before the specific text is laid, and I welcome the Minister's commitment to meet with those members who are concerned in that regard. In Northern Ireland, abortion on request for any reason will be legalised to the point at which a baby is capable of being born alive. This includes on the grounds of disability. I implore my right honourable friend, the Secretary of State and the Minister to accede to the request to have Section 9 repealed as part of the ongoing negotiations. The DUP are a pro-life party, but it actually crosses traditional boundaries, and there is widespread cross-community support across Northern Ireland. We have an evolving political landscape, and I say let the people of Northern Ireland have their say on this matter. On this, Mr. Speaker, I will bring my remarks to a close. I want a society in Northern Ireland that values life. I want to see services that will help women choose life. We want to see a perinatal palliative care centre, a maternal mental health unit and better childcare services. And that is my ask of this government. Help us create a culture of choosing life as opposed to killing an innocent little baby that does not have the voice to say, no mummy. Mr. Speaker, it is incomprehensible that the government, knowing that abortion was a devolved matter, has published consultation proposals to introduce changes which go far beyond what has actually been required by Parliament. If the government wants to maintain any commitment to devolution, I would implore them to rethink their coach and horses approach to a life and death piece of legislation. Thank you.
Can I just say we've about 5 more speakers, so if we can divvy up the time, we're going to finish about 9:30, and ideally the Minister would like, I think, about 5 minutes to come back on. So, Simon Hall.
Thank you very much indeed, Mr. Speaker, and can I first of all congratulate the Honourable Lady for Upper Ban on a fluid, cogent and passionate maiden speech, and I think the attention which all quarters of the House gave her remarks should indicate the interest with which she was heard. She spoke with great passion about the issues upon which she wishes to campaign in this place, with a great warmth of her constituency, in tribute to her predecessor and my friend David Simpson. And she spoke with a clarity and confidence about what motivates and drives her unionism. In all of those points, Mr. Speaker, she is to be congratulated, and I wish her much happiness in her years of service in this place. Mr. Deputy Speaker, how it changes. Mr. Deputy Speaker, a number of colleagues have referenced the deteriorating situation in the arenas of public policy delivery of health, of welfare, of education, and also, as the Honourable Lady for Upper Ban referenced, the intolerably high level of suicides in Northern Ireland. Now, I don't think anybody would suggest that the restitution of Stormont will solve all of those problems at the stroke of a pen, but certainly I think all of us should be motivated in this place by the idea that local decisions taken by locally accountable politicians are in the best interests of those that we serve. And therefore the imperative, as underlined by my honourable friend the Minister, for whom I must thank for the update on the issues which he has updated the House, is right to reventilate the crucial, pressing and urgent need to get Stormont back up and running. And it is maybe tempting fate to suggest that some of the rumours coming out from the discussions which my right honourable friend the Secretary of State is taking part of should indicate some cause for hope. But let us in our night prayers this evening, Mr Deputy Speaker, pray that we do see some success and the restitution of Stormont. I want to turn, if I may, albeit very briefly, to the argument deployed, or the conundrum deployed, by my right honourable friend, the member for the Forest of Dean. I understand entirely that the default position, if the talks are to fail, that there will be a tendency to say, enough with deadlines. We can't have any more deadlines. We now just have to cut to the chase. And the easiest option of cutting to the, or the easiest chase to cut to, is of course direct rule, either officially or unofficially, but to try and address those pressing issues. Now, whilst I understand the ease of that, and for some, indeed, the desirability of it, it would be, in my judgment, a retrograde step. The devolution genie in this kingdom is very firmly out of the bottle, and it would be, I think, neither desirable and possibly impossible to put that genie back in. I also think it would be the easiest thing to do for the politicians of Northern Ireland, where in essence it would effectively transpose the imperative to try to find workable solutions and accommodations to overcome historic tensions would just be put on the back burner. There would be no need for it because decisions would be taken in this place. And that wouldn't, in my assessment, just lead to a maintenance of the status quo. It would actually be a very significant step backwards into previous decades, previous years of acrimony, of bitterness, of the blame game. So I would certainly suggest, if these talks ultimately fail, and let us all repeat that we pray that they won't, then the default position will have to be fresh elections. Now, they may very well throw up broadly similar results to the last elections, but we are in incredibly interesting times electorally, I would suggest, as last month's general election illustrated, and the stark and indeed startling fact that for the first time in its history, Northern Ireland elected, albeit by a slim margin, a majority of non-unionist representatives to this place, shows that things can change, and can change very rapidly. The Honourable Lady for Upper Bann spoke about her determination to serve her community, and I know that that will be shared by all of her colleagues from Northern Ireland, whether they're from the Alliance, from the SDLP, from the DUP, and whilst they don't take their seats, from members of Sinn Féin. I think the challenge for the from the electorate to all of the political parties who hold true in their repetition of that motivation will be effectively put your money where your mouth is. If that is what motivates you in public service, you will have to find a way to resolve whatever the outstanding hurdle is, without just defaulting to the easy get-out-of-jail-free option of direct rule. New elections may very well produce a continuance of the stalemate, but it could also act as the engine to break the logjam. So whilst wishing the talks success, can I urge upon my honourable friend to resolve not to do the easy thing in those circumstances, but to trigger those fresh elections and say to the electorate, you are concerned about deteriorating standards in education, in health, in welfare, in high levels of suicide, and in other areas of public life. This is now your opportunity to either force your politicians to find a way of dealing with them through restoring Stormont, and if they can't, they may very well start to choose new politicians.
Just a few moments ago, we indicated the outcome in Northern Ireland in terms of the general election when he made the reference of the numbers of people pro-union and anti-union that were returned to this House. Would he accept from me that when I was first elected here 18 years ago, the combined numbers of people voting for United Ireland candidates came to 42%. In December last month, it came to 39%. So the vote for United Ireland parties has gone down in those 18 years. But can he outline, in terms of what he's just said about what might happen after an election to the Assembly, how he thinks the problems would change, whatever about the makeup of those dealing with the problems?
Well, the honourable gentleman makes a valid point, and one can argue percentages to the cows come home, but in terms of bums on seats, as it were, or in the case of Sinn Féin, non-bums on seats, if that's the right phrase to use, nobody on any seats, then the figure speaks for itself. And that should give all of us concern, cause for concern, and it should also motivate us who share a strong belief in the importance of the maintenance of the Union and the unity of the United Kingdom, to redouble our efforts and to strengthen our arguments and to make ever more attractive the reasons to maintain the Union. And that is as applicable in Northern Ireland as it is in Scotland, because we face as Unionists the twin challenge of trying to persuade a growing sceptical population that there is relevance for unionism today and for it to continue. And we cannot just walk through some sort of fog of presuming that the status quo almost of itself will just continue. What the honourable gentleman was asking me is that I think that the electorate, just as they decided in last month, Remainers and Leavers alike, that they wanted an end to the impasse and threw up some very peculiar results, very welcome results, as far as this side of the House is concerned, that when the electorate has had enough, they will pick up that stubby pencil in the ballot box, they will and almost use it as a sword, as they use the ballot paper as a shield to reassert what they want. And I'd make this point, and it is possibly unpalatable to many, which is, if politicians are prepared to not allow the restitution of devolution because they seek to argue over points which for many in Northern Ireland will seem irrelevant or not as pressing as dealing with health, education and welfare, then there is the risk that those electors will turn to politicians who are less hog-tied by those traditions and seek to break the impasse through having a new set of faces around the table. As I say, it may result in exactly the same sort of result. But I think we do have to, if these talks fail, then we should default to fresh elections and not just write the electoral process off as if it was just another way of staying the hand of the inevitable, which is the return to direct rule, the inevitability of which I think we should resist at all costs.
There are still 3 members seeking to speak, plus the Minister. Please do the maths and be considerate. Jim Shannon.
Thank you, Mr Deputy Speaker. And first of all, can I say how pleased I was to hear my colleague, the Honourable Lady for Upper Ban, in her maiden speech, and for her contribution. And I think we can look forward to some exceptional contributions from the Honourable Lady in this House over the next period of time. Mr Deputy Speaker, pages 9 and 11 of the report before us today deal with the abortion consultation that ran between the 4th of November and the 16th of December. The way in which the consultation was conducted was hugely problematic. I appreciate some of the issues around this consultation were not the fault of the Northern Ireland Office, but I understand they were placed in a deeply invidious position by this Parliament in terms of the timeline set out. However, conducting only a 6-week consultation during a general election campaign on an issue of this sensitivity was simply inappropriate. The consultation programme document itself had all the hallmarks of being a rushed out or at least incomplete document. Major gaps existed in it. Just a few examples will suffice to show some of the issues. No clarity was given in the document as to who will actually be performing abortions in Northern Ireland under the new regulatory framework. Will it be the private providers such as Mary Stopes or BPAS or the National Health Service? The document at no point discussed what body will be inspecting abortion providers operating in Northern Ireland. This is a hugely important question, yet no details whatsoever were provided in the document. The actual regulatory framework put forward in the document itself is without question the biggest problem with it. Despite the consistent claims of the Northern Ireland Office Minister over the years that abortion is a devolved issue and the importance of respecting the people of Northern Ireland, the consultation document adopted an expansive interpretation of Section 9 of the Act in their proposals, instead of adopting, as they should have, a cautious approach which took into consideration the way in which the law was passed. Without consultation, the known strong opposition in Northern Ireland to what had been passed. All the Northern Ireland MPs at that time who take their seats in Parliament voted against the measure, and the democratically elected Northern Ireland Assembly voted as recently as 2016 not to change the law in any way. The Northern Ireland Office went far beyond what was strictly required by Section 9 of the Act. The point has been well made by eminent lawyers and has caused huge concern in Northern Ireland. David Schofield, QC, stated in an expert legal opinion, and I quote, "The question posed to me is essentially whether the Secretary of State determined to do more than necessary to comply with the strict legal obligations of the 2019 Act. The proposals set in the consultation go beyond this, and I consider it to be relatively simple to conclude that the answer to this question is yes." David Schofield further stated, "In my view, it would be quite possible for the Secretary of State, if he wished to take a conservative approach, for instance, on the basis of concerns that he should go no further to legislate on devolved matters than the UK Parliament has strictly required in the absence of a legislative consent motion from the Northern Ireland Assembly. To broaden the availability of abortion in Northern Ireland to a lesser extent than appears to be envisaged is a consultation process to comply with the CEDAW recommendations. The proposals go far and well beyond the requirement in paragraph 85A of the report, and whilst the reports on which the consultation process responses have been invited would enable a woman or a girl who had become pregnant through rape or incest to access an abortion up to the appropriate gestation period. It would also provide access to abortion for many others who would not have had access if the availability was confined to cases covered by paragraph 85B. Mr Deputy Speaker, let us make no mistake, the radical proposals in the Northern Ireland Office consultation constitute a clear political choice on the part of the Northern Ireland Office to undermine devolution to a greater extent than the 2017-19 Parliament required. There is no requirement to import in the Northern Ireland ground C of the 67 Abortion Act, which effectively led to abortion requests for any reasons between 12 or 14 or 22 and 24 weeks gestation. I sincerely hope the Northern Ireland Office will be considering the consultation process responses, rethink their proposals. I understand they are legally obligated to introduce a new regulatory framework, but they are not required whatsoever to introduce the radical changes as they propose. Up until this point at which the other place voted for the amendment, which became Section 9, the Government was entirely consistent in its respect for devolution and abortion when it was a devolved matter to the Assembly. But let us be clear that certainly since 4th of November, when the consultation was published, the main actor within the British Constitution has not been the Parliament but the British Government, and wilfully and completely unnecessarily proposing an abortion regime that departs far from radically what we experienced until October last, when Parliament required. The people of Northern Ireland do not want to do this. Rich, poor, Protestant or Catholic, young and old, all stood together, storming some 20,000 people, rising above political opinion, religious divide and any other consideration to beg this place not to do this awful thing. Yet, yes, protect women, yes, protect a better way but abortion on demand taking place every 2 minutes throughout the night and day in the mainland is not what we need in Northern Ireland. 100,000 people live today because of the legislation that we have in Northern Ireland. We do not have to introduce this radical change, which is the difference between life and death in this way, Minister, or state that you have time to rethink. Please take this opportunity to do so. Allow the voices of Northern Ireland people to be heard, their voices acknowledged, and right of life to be respected. Can I just very quickly, in closing, mention about the same-sex marriage? And I posed this question to the Minister because I attended the Christian Institute meeting in Belfast some 4 to 5 weeks ago. At that, they were very clear, and they sent out some information to me in a letter. As things stand, there is no protection for churches, and the Northern Ireland Office and the Secretary of State and the Minister of State must change this. Not simply for Christian denominations, but for Jewish and Muslim friends who have the same deeply held beliefs as I have. We are never in a place to bully people or belittle them, but in a country which cherishes our freedoms and acknowledges that the foundation of this country is the Word of God. The protection of those Christians to say that they must hold to biblical truth must be enshrined within the law. The good news, of course, for Northern Ireland and the integrity of the British Constitution is that the proposals in the abortion consultations were only proposals. The British Government does not need to discharge its responsibilities under Section 9 to introduce these specific proposals. So therefore I would call on the Minister and call on the Government to step back from the brink and only introduce the legislative changes that Section 9 actually requires. Decency and honesty requires you to do so.
Mr Deputy Speaker, I've spoken this evening to the Taoiseach and the Secretary of State about the very sensitive period that we're going through in terms of the negotiations. But as has already been said by many other members, time is well past. Tomorrow we will have been out of government for 3 years. The people that we represent haven't had a government for 3 years. Just let that sink in. Look at the consequences for our health service. Our health services are at breaking point. Our school budgets are at breaking point. Our nurses, for the first time, are on strike right now. They have been used as a political pawn in this process because of our failure to deliver for them and the people who they look after every single day of the week on our behalf. And I want to agree with the Shadow Secretary of State on this. No matter what happens in our talks process, take the nurses and the healthcare workers out of this process. Provide them with the pay that they work for, that they deserve, that they're entitled to, and they should not have to strike one more day in order to get their full entitlements that they absolutely and totally deserve. This has gone on for far too long, Mr Deputy Speaker. I, for one, as a leader of the SDLP, have already committed to compromise on behalf of the people who we represent. Other parties now need to come and step up and get ready to compromise, because the deadline is Monday, and the deadline should stay Monday. We cannot drag this out any longer. We cannot drag it out any longer, because the people who we represent have screamed very, very loudly at the last election. They are fed up with it. And what do they want? What are they saying to us? They're saying, get back to work. Because compromise is not a dirty word. We have learned this through many, many difficult negotiations, through many, many years of coming together, of bringing our communities together. We cannot lose that progress. We cannot go backwards. And it is up to us to sort that problem out. But let me just say one thing. There is nothing called direct rule anymore. That's gone. It is outlawed. There's nothing called direct rule anymore. We cannot go back to the days of rule from this place over the people of Northern Ireland. The Good Friday Agreement, the St Andrews Agreement, and every agreement since states that devolution is how we do our business now. And if we can't have devolution, and we shouldn't countenance this, but if we can't have devolution, people need to understand that the automatic response to that is not direct rule, because the nationalist population will not accept it, the Irish government will not accept it, the St Andrews Agreement has ruled it out as an option. So what do? We have to recognise that voice in governance has to be given to both sides of our community, to all of the minorities, and we're all minorities now in Northern Ireland. That means, and people have to be aware of this, if we do not compromise, the next step is not rule from London. The next step is some form of joint rule from London and Dublin. People need to recognise that when we're talking tough in these negotiations. It's time now to bury the hatchet, because the issues that are at stake in these negotiations, as important as they are, and I have strong views on all of them, they are not as important as people dying on waiting lists. They are not as important as nurses not getting paid properly, and they are not as important as our schools not being able to fund the educational services that we need to give to our young people.
Harry.
Thank you, Mr Deputy Speaker, and I'll try to be very brief given the pressures of time. I just want to first of all start off with the main focus of the debate around the executive formation and hopefully the successful return of devolution, and say I hope this is the last time that we have a debate on the Executive Formation Act. There is only one way forward for governing Northern Ireland, which is through sharing. That reflects the very complex nature of our society and the need to ensure all traditions and identities are reflected in terms of our governance. And while I wouldn't go quite as far as my colleague from Foyle in talking about joint rule, any notion of direct rule or direct responsibility from this place in London does need to take on board some form of Irish dimension. And that is a very difficult balance to getting right. If it's put in too strong, it will annoy unionism. If it's too weak, it will annoy nationalism. That's why the careful balance of the Good Friday Agreement is so particularly important. I don't want to see elections in Northern Ireland. We have to ensure we have devolution restored as quickly as possible. But in the event that we don't get talks resolved and a proper outcome, we can't simply carry on with what we've been doing for the past 3 years. That simply isn't tenable. Something has to give in that system. The final point I want to make is just in relation to the two social issues that have been brought up. And while the parties from Northern Ireland today were putting on a united front in relation to some aspects of Brexit, I fear it's going to break down at this particular point in time. I want to put on record that while my party has a conscience position on the issue of abortion, I think like most parties in this House, personally speaking, I was content to see the House legislate in terms of abortion reform last July. I wasn't at all offended as a then member of the Northern Ireland Assembly, because we weren't sitting for the best part of 3 years, and even before that, efforts at reform had stalled. Biology does not change whenever you cross the Irish Sea. Women are women, and the basic reproductive rights have to be recognised as fundamental issues of human rights. And it's important that we also bear in mind rulings of the UK Supreme Court and also the High Court in Belfast. So the floor has now been established. The guidelines can either be put through a restored Northern Ireland Assembly or here in the Houses of Parliament. Those are the choices, but reform has to take place, and I believe there is majority support in Northern Ireland for reform. That's also the case in terms of equal marriage or same-sex marriage. And I think the model in the rest of the UK is readily transferable to Northern Ireland, with only a few minor tweaks here and there. No one is arguing that churches should not be given some form of opt-out in terms of respect for their doctrines. The issue is how far that goes in terms of what happens. I think we do need to be very, very mindful of people's rights as human beings in terms of employment and other aspects, and not go down for a much more extreme form of constraint on that important set of reforms. So I think it's important that we take them over the line in terms of a restored assembly, but if not, the House of Parliament should do what is important in terms of recognising people's rights in Northern Ireland. But fundamentally, let's get the assembly restored over the coming days. Thank you.
Minister. Thank you, Sir Roger. And excuse me. Can I first of all congratulate the Honourable Lady on an excellent and powerful maiden speech, and making a clear and very pronounced contribution to this House on her first outing. I'm sure we will hear a great deal more from her in the months to come. And I think we've had a debate in which there has been actually once again the consensus that we all want to see the devolved institutions restored. We all want to see the agreements respected and seen through. And I'm grateful to the SNP spokesman spokesman and for the opposition spokesman for their support for that position. Clearly, we've heard, as ever in these debates, a wide range of opinions. In the previous debate, I was getting beaten up very heavily by pro-life colleagues on the opposition benches. On this occasion, by pro-choice colleagues on the opposition benches. On this occasion, perhaps the voice was slightly more loudly heard from the pro-life people, who I am very happy to meet to try and address the concerns further and to ensure that we take this forward in the best possible way, in a way that is respectful of the concerns that are there both in the community in Northern Ireland and more widely. But we do have to recognise that we are under a legal duty under Section 9 of the Act, and we will be continuing to work to put in place the regulations by the 31st of March that provide access to abortion consistent with the CEDAW report. The Right Honourable Gentleman opposite asked about what if the executive were restored and what we could do then. If the executive is restored before the 31st of March, we would welcome discussions on the regulations that will be made and questions on implementation, which of course will be taken forward by the Northern Ireland Department of Health. And as these are devolved matters, any future reform after March 2020 can of course be considered by the executive and the Assembly, subject to such legislation complying with convention rights and the usual Assembly procedures. It's yet another one of these issues where I think if we want the concerns and views of people in Northern Ireland to be heard properly, we want to make sure the institutions are in place. He asked, and my honourable friend for the Forest of Dean asked about the legacy system. I can't give him specific dates at this moment, but I'm happy to come back to him when I can on that. We do want to work rapidly on this issue, and we are clear that the current system for dealing with the past has not been working well, needs to be reformed. We will continue to work with partners to seek better ways of dealing with legacy issues that provide better outcomes for victims and survivors and do give veterans the protections that they deserve. He also asked about the historical institutional abuse. I'm very grateful for his support, that of the opposition, and that we had across the House in actually getting that legislation through before the election. It was very important that we did so, and I know he moved heaven and earth to make sure that we could, as did my Secretary of State. The Northern Ireland Civil Service have now established a project board, and work continues at pace to deliver the scheme. The head of the Northern Ireland Civil Service met with the victims and survivors groups on the 17th of December and set out the timetable for redress, and the application process for the redress appeals is open from the end of March 2020. I hope that provides some update on the issues that he raised there. He raised the issue of business rates, and I recognise, and having been a territorial minister in both Scotland and in Northern Ireland, whenever I travel, I hear concerns about business rates, as indeed I do in my own constituency, that these are fundamentally devolved matters that need to be dealt with by the devolved administration. He mentioned that there had been recent valuation and there were concerns about this, and I absolutely recognise that. The best place for those concerns to be addressed and to be taken up is in the Northern Irish Assembly, and of course this is yet another factor that means we want to get it back up and running. With regard to the nurses' pay issue, I have complete sympathy for what people are saying about how unacceptable the situation is that people should have to be out on strike. It was the decision of the last Northern Ireland Irish executive to diverge from parity with England and Wales in terms of health workers' pay, but the UK government does stand ready to support a deal that will help to resolve the pay dispute. Once again, if we can get an executive in place, we will work with them to ensure that this can be done, and that the very urgent issues that my honourable friend, my right honourable friend, alluded to with regard to the health situation in Northern Ireland are addressed. To his further point on the legacy system, we will look at legislation on this at the earliest opportunity, but it is clear that legislation to improve the legacy system in Northern Ireland will need to be agreed by the UK government and have the support of the Northern Ireland executive, and once again it comes back to how crucially important that is. The honourable lady for East Renfrewshire rightly spoke about the urgency and importance of talks to restore the institutions and the pillars of the peace process. pillars I think that everyone in this House is united in supporting. And she also, rightly I think, was very clear about the devolved nature of health in Northern Ireland. One of the reasons why we absolutely want to continue to lean into the talks and get devolution back up and running. My honourable friend for Congleton made a passionate speech, speaking with her usual passion and knowledge of this issue, and urged us not to go so far as the consultation suggests. I mean, clearly this is a consultation, it is a process of listening, and we will engage with the responses there before we come out with any formal government response. But I am happy to meet with her further to see how we can take on board any of the concerns that she has raised, and I will write to her with regard to any further people beyond those that I mentioned that have been involved in the consultation. I mean, a part of the reason why I mentioned those groups in my speech on this occasion was, of course, on the previous occasion, the Secretary of State had talked about meeting with church groups, and we had objections from some of the members of the opposition, but we were talking to church groups and not necessarily the women's groups, so I did want to put some of those on the record. But she will recognise that it's important that we've also engaged with the Royal Colleges and the medical professionals on these issues. To return to the Honourable Lady's fantastic maiden speech, she was very clear about the strengths of her community in Upper Bann and the attraction for tourism and as a place to visit. I look forward to visiting and certainly hope to be able to make many more visits within Northern Ireland in the near future. And I think we heard from my honourable friend for North Dorset and my honourable friend for the Forest of Dean, the concerns about what could happen on the 13th if talks are not successful, if we don't deliver that successful outcome to talks. I think it's clear none of the options are attractive ones. We want to make sure that we can get the executive back up and running in place, get an assembly sitting in Northern Ireland to deal with these issues, and that is why I share the hopes of many in this House that this is the last debate we will need to have on the EF Act. Thank you.
Question is, as on the order paper, as many of that opinion say aye? No, the ayes have it. The question is that this House do now adjourn. Steve Reid.
Thank you, Mr. Deputy Speaker, and I'm very grateful for the opportunity to raise this important and alarming issue this evening, and I'm grateful to colleagues who have stayed late to be present during this debate. SPAC Nation are an organisation that's been in the news recently, and I'd like to start off by expressing my gratitude to Nadine White and Emma Yule at HuffPost, who have carried out some extraordinary investigative journalism to bring them to light, and also to Greg Mackenzie and the excellent BBC Panorama team for their work, as well as many others working in the media and in the press. When I first became aware of SPAC Nation, I thought, as many have done, that it was just another church. I started to think differently when one of their leaders stood as the Conservative candidate in a Croydon Council by-election. Now, there's nothing wrong in a church leader standing for election, of course. What was odd was to find hundreds of young members of this so-called church shouting abuse at other parties' canvassers, shouting obscenities at the council leader, and intimidating voters on their own doorsteps, including by video recording them. When I tweeted my concerns about this unchurch-like behaviour, I was inundated with emails and phone calls from young people and their parents making alarming allegations about SPAC Nation. I took a full 2 days to phone them all back, but from that I was able to piece together what was really going on inside this organisation. I am convinced that SPAC Nation is a cult. They advertise events targeted mainly at young black people in poorer parts of London. They offer free food or free bowling sessions to attract young people to come along. The young leaders vet the young people who turn up, and they then target those who appear to be the most susceptible. They befriend these particular young people, and they invite them to further functions and events, including dinners. One of the organisation's leaders will start phoning them, sometimes several times a day. They're then given lifts by that individual to meeting. Then what appears to be brainwashing starts. They're told that if their life is unsuccessful, if their family is poor, That's because they're not giving enough money to God. They call it seed. If you give seed to God, as much as you can lay your hands on, you will become rich. This is the message they try to pump into these young people's heads. The organisation's leaders display extraordinary wealth. They drive cars worth hundreds of thousands of pounds. They wear Rolex watches and expensive designer suits, and they live in multi-million-pound properties. All of this way beyond the experience of the young people that they are targeting. They tell these vulnerable young people that they became rich by giving seed to God and tell them they can have the same, but first they have to give, and by any means possible. Some young people are encouraged to break their links with their families and move into properties rented by the organisation's leaders. They call them trap houses, the term used for drug dens in the United States. A woman leader of this organisation running one of these trap houses where vulnerable young girls were placed has 27 convictions for serious fraud. No vulnerable child should be allowed anywhere near her. Once in these houses, the control and coercion becomes far more insidious. One young victim told me they had prayer sessions that she described as brainwashing for up to 8 hours a day. But the emphasis wasn't on God or spirituality, it was on wealth and money and the need to give seed to God in order to get rich. Once the organisation has control of a young person's mind, they pressure them into making fraudulent personal loan applications so they can hand the money to the organisation's leaders. They're pressured into setting up fake businesses so they can apply fraudulently for business loans. The so-called pastors show the young recruits how to fill in the application forms with false information. In some cases, they fill the forms in for the young person simply to sign. In at least one case, an application was made in a young person's name without their knowledge or awareness that it had been done.
Would the honourable member give way? On SPAC Nation and the financial implications of some of their dealings, my honourable friend will be aware of the case of the late Mrs Osinlaru, who seems to have obtained a loan for £150,000, a secured loan on her house. She tragically passed away, leaving her 2 young adult daughters and 13-year-old son in the house, unaware that there was this control of the house, which was later repossessed and a bailiff's warrant secured, only stopped because of the presence of the young 13-year-old son. That family risked losing their home and becoming homeless for a loan they didn't know about, and their mum has passed away. I have written to the church. They have admitted that they were involved in securing or helping secure that loan. Does that give my friend further concern?
I'm very grateful to my honourable friend for raising yet another alarming case of what appears to be a form of fraud and deception perpetrated upon a family who had just lost their mother and seems to have been deliberately intended to disinherit her children. So I'm grateful for her for raising that case too. And there are many ways in which they appear to be perpetrating fraud in order to enrich themselves, the leaders of this organisation. I've spoken to young people who absolutely sickeningly were taken to private clinics to sell their blood with a so-called pastor pretending to be their parent to sign consent. Young people I've spoken to were coached to commit benefit fraud. I've met students and spoken to their parents who were coerced into handing over their entire student loans before then being taken to banks to raise further money through personal loans. So they lost their ability to continue an education and ended up in serious financial debt. Tragically, where criminal exploitation is taking place, there is often also sexual exploitation. One young woman told me she was just 16 when she moved into a trap house, and in her words, everyone was having sex with everyone else. It was disgusting. I asked her to clarify whether she meant older pastors having sex with younger girls, and she said yes. When this young woman complained to her pastor, she was taken to the organisation's leader, who told her that if she complained to the police, it would rebound on her because he was powerful and had friends in high places. He made that claim look real to these vulnerable young people by inviting politicians and senior police officers to his church services. He even met the Prime Minister in 10 Downing Street. All of them, I believe, thought they were engaging with a church that was helping vulnerable young people. But in reality, they were being used to intimidate young victims to stop them from speaking out. This is not an organisation getting young people out of crime, as it claims. It's an organisation criminalising young people for its own ends. SPAC Nation is operating right across London and has already expanded into other cities, including Birmingham and Leicester.
Can I just thank my honourable friend for actually securing this debate and for actually raising what is clearly quite an important issue. But does he agree with me? It's criminal activity and it's preying on the most vulnerable. And it's essential that the government really does need to intervene and take action on this.
I'm very grateful to my honourable friend for making that important point. I'm looking forward to hearing what ministers have to say afterwards about how we can work constructively and collectively together to tackle many of the problems and horrors that we're hearing associated with this organisation. As I was saying, the organisation started in London. It seems to have spread right across the city, but it's expanding into other cities, including Birmingham and Leicester. They have no fixed location. They don't have a home church, which makes it much harder for the authorities to track them. There's not a home police command unit which is keeping track of what they're doing. There's not a local safeguarding board which is keeping track of the risks to young people. They hold their services in vast venues in many different boroughs and now different cities across the country. I've reported every single allegation that was made to me, to the police and to the safeguarding authorities. But I am deeply worried that more has not been done to stop this organisation from exploiting vulnerable young people. SPAC Nation itself claims to have up to 1,000 young people involved right now. Every one of those young people is potentially at risk. They appear to have up to 15 trap houses scattered across London. Every young person inside those properties is potentially at very serious risk. A teacher in North London told me that SPAC Nation had been recruiting schoolgirls outside the school gates. A youth worker in Croydon told me they had been recruiting outside the youth centre. They are targeting young people so they can exploit them, and it is imperative that they are stopped. I have some questions that I'd like the Minister to answer this evening, if that's possible. Allegations about this organisation have been circulating widely in the black community and on social media for up to 4 years. So why has police intelligence failed to pick anything up? I was able to find out most of this information over a couple of days, speaking to people and then Googling on social media. If I can do that without the resources of the police, why has police intelligence failed to recognise what is happening to potentially thousands of vulnerable young kids across this city? What action can be taken immediately to stop this organisation recruiting any more vulnerable young people for abuse and exploitation in my constituency and beyond? Given what we have heard, given what victims have told us, we surely cannot allow this organisation to continue targeting other young people for abuse and exploitation when it's possible for us to take steps and action to protect them. What help can be given to young people involved in SPAC Nation now, including those living in trap houses who need to get out urgently before they are further criminalised, their family relationships destroyed and their future lives ruined? And why has no help been offered to potentially thousands of young people who have managed to get away from SPAC Nation but are left burdened with huge debts, criminalised, many of them homeless, and many of them suffering trauma and mental ill health? We cannot simply leave these young people to suffer the consequences of abuse by an exploitative organisation. There are... Yep.
I have to say that what he has illustrated tonight in the House is worrying to every one of us who has heard it, and I think it's hard not to be moved and feel concerned about it. the magnitude and the massiveness of what he has outlined, the Honourable Gentleman has outlined, would indicate to me that it wouldn't just be an ordinary police investigation. It probably needs a specialised unit set aside with the resources and manpower and womanpower to try and make it, to have the investigation concluded and to put an end to what's going on. Exploitation of young people is abysmal and is despicable and needs to be addressed.
I'm very grateful, as always, to the Honourable Gentleman for his intervention, and I agree with every word that he's said. Now, what concerns me further is that there are worrying echoes of the Rotherham child abuse scandal in what's happening here. In that case, vulnerable young girls' allegations of serious abuse were dismissed because they came from poor or difficult backgrounds. And it's the same with SPAC Nation. I can't help wondering, as one desperate mum told me, if this was happening to white middle-class children, would it have been ignored for so many years? Would it have been allowed to go on in the way that it has done? We need to address that question because it is a real feeling and concern in the community. In my opinion, SPAC Nation is a criminal enterprise masquerading as a church because that gives them access to vulnerable young people and cover for exploiting them. To every young person who's afraid or at risk from SPAC Nation's activities tonight, I'd like to say this. This organisation might seem powerful, but we are stronger and we are on your side. We will not stop collectively until every young person is safe. We will not stop until the wrongdoers inside SPAC Nation have been brought to justice. We will not stop until this dangerous, manipulative organisation can do no more harm.
Minister.
Thank you. I would like to begin by thanking the Honourable Member for Croydon North for calling this debate and raising these very serious concerns. I would also like to thank his constituents and all those who've had the courage to speak up and bring this situation to his attention and to our attention, and to thank other members who've stayed here tonight to intervene and contribute to this debate. Now, I'm answering this debate as the Minister for Arts, Heritage and Tourism on behalf of the Minister for Civil Society, Baroness Barron, who sits in the House of Lords. And the allegations concern a charity, and charity policy sits within our department. But I'm also very grateful to have the Minister for Safeguarding and Vulnerability from the Home Office on the front bench with me, and the Minister for London and another member for Croydon. I've listened very carefully to the Honourable Member. I've also read a great deal of the coverage in the media, and I also watched the Panorama documentary, and I found the accusations deeply concerning. These are very serious allegations, and they clearly must be properly and urgently investigated. On the 5th of December last year, the Charity Commission opened a statutory inquiry into SPAC Nation, and that inquiry is looking into its finances, governance and safeguarding, and its overall compliance with charity law. That was, however, not the Charity Commission's first engagement with SPAC Nation. They launched a regulatory compliance case looking into SPAC Nation in April 2018 and then issued an action plan to its trustees in June 2019. And the Charity Commission was not satisfied with SPAC Nation's response to the action plan, and that's why, together with the further allegations and concerns that have been raised in the media and by the Honourable Member, they launched their statutory inquiry in December. The Commission has also issued an order under Section 84 of the Charities Act 2011 requiring the charity to bank money that it holds as cash. I hope the Honourable Member will understand that whilst the Commission is carrying out its statutory inquiry, I cannot comment on the specific allegations in this case. A report will be published by the Commission once the investigation is complete. Now, whilst the Charity Commission cannot itself investigate criminal offences, it does have the power to refer charities to the police, and in parallel, I understand that the Met Police is already reviewing these allegations into fraud and other offences that relate to SPAC Nation that the Honourable Member has raised, and I believe has raised directly with them. In my opinion, one of the most upsetting aspects of these allegations is the alleged exploitation of truly vulnerable young people. And the suggestion that the very people who most need help and support may be being taken advantage of, that's particularly worrying. I'd say that is a known risk, hence a huge amount of work that has been and is being done across government to improve safeguarding practices to make our society safer for young people. Safeguarding in... Yeah, I'm very happy to give way.
I thank you for giving way. If you agree that this is a really important issue in terms of the safeguarding of young people, the reality is that this is still happening now to a number of young people, not just in London, but as my honourable friend mentioned, across other cities. Is there not something that the government can do in this now time to actually investigate some of these really serious allegations where a number of young people continue to be exploited?
So, as I think I'm trying to make clear, that these are allegations which are being investigated by the Charity Commission and being reviewed by the police, and it's not something that government can intervene in at this point. But I think this debate is certainly raising this very much up the agenda, and for sure is making sure that there is a great deal of awareness of the situation. And I will do my best to address the questions as I proceed. I just want to continue to talk a bit more about the really important role of safeguarding in charities. I think it is really, really important because it's exactly that should prevent exploitation of young people, or when exploitation happens, make sure that there is a rapid and effective response. But I want to make it clear how seriously the government takes this, that since 2018 we've invested over £1 million in the Domestic Charities Safeguarding Programme. We've been working with charities, other partners, including the National Crime Agency, to raise awareness of safeguarding, to ensure that charities, whatever their size, large and small, know their responsibilities, know how to handle concerns quickly, and can easily access the advice. The Charity Commission has also launched a whistleblowing helpline to help people report safeguarding concerns. And I would encourage anybody, and obviously members here can also refer people to do this, if they've witnessed or experienced or concerned about wrongdoings in charities, to use that as a means of reporting it. I think allegations such as those raised by the Honourable Member do reinforce the importance of this really vital work on strengthening safeguarding, and there will be further announcements on that shortly. Protecting people from harm must always take precedence over protecting a charity's brand or status, and charities must be clear that they will listen to safeguarding concerns, and those concerns must be treated promptly and seriously acted on. The majority of charities take their safeguarding responsibilities extremely seriously. And so I think it's right to make sure that we recognise that, and then the action is taken by the Charity Commission and is necessary, local safeguarding authorities and the police. However, many of the Honourable Member's concerns do relate to police matters, who, as I've said, I understand are reviewing the evidence that they have received. Now, can I suggest, if he hasn't done so already, that he raises these concerns about policing with both the Mayor of London and with the Commissioner of the Met Police. Now, coming to the government, the Home Office is working extremely hard transforming its approach to dealing with crimes against vulnerable young people. They have invested significantly in a programme of reform to help the police respond to changing crimes, including child sexual abuse. Child sexual abuse has been prioritised as a national threat. The Home Office are empowering police forces to develop their specialist skills and expertise, increasing the capabilities of the police to tackle this terrible crime. I will indeed. Can
I thank the Minister for giving me way, but I'm just going to ask a question, and forgive me if I'm the one being ignorant on this particular point, but you've asked my honourable friend to, if he hasn't already done so, to raise this with the Mayor of London and with the Police Commissioner. The Home Office is the government's responsibility, and this sounds to me like a Home Office issue that the government need to be looking into. So can she just clarify whether or not this is not an issue that the Home Office should be addressing?
So I think the important point is this is a police matter, and that's why the Mayor of London, as the Police and Crime Commissioner for London is the appropriate person to raise concerns with. However, there is a bigger picture point, which is why I'm talking about what the Home Office is doing about acting to prevent and respond to crime for young people, and particularly on sexual abuse. And I just want to come to something which is very relevant to the specific topic. So in 2015, the Home Office launched the independent inquiry into child sexual abuse, and in May last year, that inquiry announced its final investigation strand into child protection in religious organisations and settings. So that strand of the inquiry is now examining the nature and adequacy of child protection policies, practices and procedures, and will consider whether safeguarding these kind of settings needs to be strengthened further. Also looking across government on safeguarding, the Department for Education in July 2018 updated their statutory guidance on interagency working to safeguard and promote the welfare for children, and is funding a £2 million tackling child exploitation support programme to help deliver more effective response to child sexual and criminal exploitation, gang and drug involvement. Yes, indeed.
To her for giving way. But can I ask, how much longer does she think this organisation should be allowed to access vulnerable young people and exploit them?
So I'm doing my best to make clear how very seriously I take these allegations, and I know that the other ministers with me on the bench take these allegations very seriously, but they are being investigated, and therefore the honourable member puts me in a very difficult position to ask me to say things which would be inappropriate for me to say at this dispatch box. I will do my one thing. I will do my best, also recognising that I may not be able to answer all his questions right here and now, to follow up and write to him with the best possible answers that I can give. What I can also say is my honourable friend, the Minister here from the Home Office, has suggested that she might be able to meet with him and the other Croydon MPs to discuss the wider issues which are brought up by the concerns that he is raising. Okay.
I didn't mean to put her in a difficult position or to be disingenuous in any way. I'm just concerned that given the severity and the number, the volume of the allegations and the type of allegations that we're hearing, is there nothing further that can be done, perhaps by the government working with the police and crime commissioners, wherever those that may be necessary, or with the police forces where it may be necessary, to prevent this organisation, even if temporarily, from being able to stand outside school gates, stand outside youth centres and target young people? I'd be happy to work collaboratively with her and colleagues on seeking an answer to that, because I understand I haven't given warning of that question this evening, but if there was some way we could look at working together to prevent any more young lives being destroyed, even while investigations are going on, I would be immensely grateful.
Yeah. Would the Minister give way on that point?
Can I just respond to that point? I'm sorry, I cannot give a different answer standing here, but what I do also want to say is I think none of us would want to say anything this evening that might perhaps prevent an effective investigation taking place, or prejudice to the outcome of that in any way that might be unhelpful. Given how serious these allegations are, let's make sure that they can be effectively investigated and pursued.
Thanks to the Minister for giving way. She's been very generous. I just wondered, the Charity Commission can often move very slowly. And given the seriousness of the allegations, would there not be a possibility of suspending charitable status while the investigations are going ahead? Considering other charities from memory who deal with young people, I am aware that this has happened in the past.
That's fantastic. Very good, very good.
I'm very happy to write back to her with a full response to that question. But let me reiterate that I know that the Charity Commission is, as I said before, investigating, and also because they don't look into criminal activity, but the police are reviewing these allegations. So those two things are very much happening. One thing before we finish, I want to just put the record straight on, is that I do understand that the pastor the honourable member referred to indeed went to number 10 Downing Street, but I have been told he did not meet the Prime Minister, and I think that was appropriate. My understanding is that he attended a round table along with 25 other church leaders to discuss youth violence, and it was in that context that he was in number 10 Downing Street. Just before I conclude, I do want to make the point, I think it's an important one to make, is to say how mindful I am, against the context of this debate, what an important role that religion, faith and worship play in our society, and what a significant and important contribution that many, many religious charities make to our communities, that they often the first in and last out of marginal communities, providing invaluable help and support for those most in need, including many black majority churches up and down this country who support their local communities, contributing positively to wider society. And I think that's a very important point to put on the record. But say in conclusion, I'm very happy to say I will write back to the honourable member. He has the offer of a meeting with the Home Office Minister, discuss these wider issues, as I said, in principle. But can I thank him for calling this debate, highlighting these very serious allegations. His concerns have been fully heard by me, by the other ministers here, and I should think actually many thousands via the media coverage that this has received. The crucial next step is for the Charity Commission and the police to investigate the allegations and to take appropriate action.
The question is that the House now adjourn. As many of that opinion say aye. Aye. Ayes have it. Order. Order.
House of Commons sound. House of Commons sound.